Free them all?
We're saying
Free 'em all,
Mumia
man.
Abu
We
Jamal,
used to take
Oscar
cases.
Grant,
Free 'em all. The positive energy is everything to us. So again, thank you guys. Appreciate it.
Thank you so much for having us. Thank you.
Thank you.
So justice for Tyree, you guys see it here with the Nichols family and all the others that are out here fighting for justice. Getting the fuck out of here. Hey everybody. And I'll be so serious. Hey, y'all. I'm sorry, y'all. Happy, what is today? Saturday. I'm so discombobulated, you guys. I've been up for days. This is crazy. I was about to cancel this live again, y'all. I ain't even gonna hold y'all. I was really about to cancel it. But anyway, welcome to the channel. It's your girl Hollywood Next in the building, bringing you guys yet another one. Well, if this is your first time, I want to say welcome to my channel. If you're returning, you already know, welcome back. What we do over here is break down a lot of these case laws and just see the injustice that's being out here. Now, if you guys have been following the YSL trial, you guys know that the motions have been put in because they're trying to get this case dismissed, rightfully so, okay? And so I'm going to read the motion to you guys, and I'm going to break it down to a science for all my viewers to understand exactly what's going on in this here motion. So this is the list. Actually, this is the Superior Court of Fulton County, state of Georgia versus Jeffrey Williams. So this is the motion for a fair trial, as well as a motion for a list of persons who participated in any ex parte communications with the court, and the topic of same motion for mistrial based upon judicial and prosecutorial misconduct, and thus bar retrial. Okay, so what that means is that there was a lot of prosecutorial misconduct. Okay, and if you guys was following the Alec Baldwin case, then you already know that case recently was dismissed as of yesterday, okay, because of the prosecutorial misconduct and withholding of evidence. So if y'all following that, stay tuned, because there's more to come with that case, because I believe the prosecutor is going to suffer some type of repercussions, okay? So anyways, getting into this here, this is like 13 pages, so it's a real short read for me. Hopefully you guys can stick it out. But anyway, comes now Mr. Jeffrey Williams by and through undersigned counsel, and hereby files this motion for a fair trial, as well as motion for a list of persons who participated in any ex parte communications with the court, and the topic of same motion for mistrial based upon judicial or prosecutorial misconduct, and thus bar retrial in the above reference case. In support of this motion, Mr. Williams shows as follows. 1, Mr. Williams is innocent. Okay, let's just put that out there. He is innocent. We're talking about Young Thug, YSL Young Thug, okay, of all crimes in the above reference indictment. From the inception, this trial has been constitutionally unfair, as this court has failed to be impartial to Mr. Williams and / or his counsel, and has been objectively biased in favor of the prosecution. Some examples of same include, but not limited to, the below. Prior to opening statements, this court ordered all parties to share with each other any demonstrative aids that they would seek to display to the jury during opening statements that were to begin on Monday, November 27, 2023. So that objections could be made prior to presentation of the opening statements. You have to go to YouTube, dated November 15, 2023, at the 8-hour 15-minute mark and 13 seconds through 8 minutes 16 seconds. 16 minutes and 52 seconds. Okay, so on Friday, November 24, 2023, at 4:58 p.m., Lawyer Love shared her purported demonstrative aid via email during opening statements. However, Lawyer Love showed a completely different, never, and I hope you guys are tuned into this, never before seen demonstrative aid, which was in clear violation of the court's order. Okay, so they also are directing us to go to see YouTube, dated November 27, 2023, at the 1-hour 59-minute mark. Okay, through 2 hours and 9 minutes and no seconds. Okay, so the court denied Mr. Williams' timely motion for mistrial, CII below, and there were no consequences met out by the court for lawyers Love intentional misconduct. So again, YouTube dated November 27 at the 2006 minute mark, 55 seconds through 250 in the 28-second mark. During the same opening statement, Lawyer Love defied another court order by introducing to the jury the undersigned counsel had represented other people charged in this case. Okay, granting Mr. Williams' motion in Lamine number 23 attached here too, specifically during her PowerPoint presentation. Lawyer Love highlighted to the jury that undersigned counsel represented indictee Blaylock. Again, there were no consequences meted out by the court. Okay, so again, this is definitely misconduct, prosecutorial misconduct, in my opinion, just based off those little readings so far. There's another example that they dated and time-stamped on us to review on YouTube. Also, Lawyer Love accused undersigned counsel of knowingly and intelligently misrepresenting to the jury the witness, Mr. Bean, was taken to Grady Hospital by police directly from the scene of his arrest on September 11, 2013. At a bench conference, Lawyer Love falsely stated that she had evidence on her table to prove that undersigned counsel fabricated evidence, as Mr. Bean never went to Grady Hospital on September 11, 2013. Now, my question is, why will they not just recuse themselves or give these individuals a fair trial? What is it that's really the cause and the effect that's making them want to hold on to this case? It's, in my opinion, just based off of watching and seeing what I've seen in the Alec Baldwin case with the withholding of evidence. This is given that same, just a different city and state. Okay. So now, Grady Hospital on that day. Now, Lawyer Love's allegation against undersigned counsel were proven beyond my doubt to be totally knowingly false. Yet the court did not admonish Lawyer Love at all for falsely accusing another of the bar of being untruthful. And there's another dated, YouTube dated March the 14th, 2024. There's a minute mark for that. Okay. And then there's just a lot of minute marks. Now, over Mr. Williams' objection, when the state was attempting to introduce the January 26, 2015 social media posting for co-indictee Garlington's account during the testimony, the detective or in the detective's during the testimony of Detective Gaither, Lawyer Love told the court that only Mr. Williams' voice could be heard on this video / audio, except for one other voice saying words like "yeah" in the background. Undersigned counsel told the court the Lawyer Love was incorrect and that several persons' voices were audible on the social media posting. Lawyer Love continued to falsely accuse undersigned counsel of misrepresenting facts to the court. Of course, lawyer Love was proven to be untruthful in her false allegations of wrongdoing against undersigned counsel. So I'm just saying all of this, these lies that are being told by, the counsel, lawyer Love, is given, just get off the case. And that's just my opinion. Y'all leave y'all's in the comment section, okay? Although it was objectively proven that lawyer Love falsely accused another member of the bar of misconduct, lying to the court did nothing to admonish lawyer Love. Okay, so this pattern of permitting prosecutorial misconduct illustrates that the court wrongly favors lawyer Love and the state of Georgia in this case. And then there's another date on April 24, 2024, where we can see all of these claims on play out right here on YouTube by going to these particular minute marks. Okay, so on Thursday, June 6, 2024, as well as Friday, June the 7th, 2024, lawyer Love falsely accused undersigned counsel of purposefully extracting and tampering with jail records of Mr. Copeland. Okay, and this is critical to the case because Mr. Copeland is kind of like the state government's key witness, okay, in this here trial. So, well, one of them, I'll say. So anyway, this was another knowing malicious false allegation by lawyer Love. The court remained mute and failed to admonish lawyer Love. Here's another date, June the 6th, 2024, as recent as that, okay? And then again on June the 7th, 2024, and there's minute marks for all of this, right? So on Friday, June the 7th, 2024, lawyer Love falsely accused counsel for Mr. Copeland of violating his ethical duties to his client. The court remained silent while lawyer Love hurried more false allegations. And we can also see that on June the 7th, 2024. There's a minute mark in the video attached to here. In the jury presence on separate occasions, the court wrongly accused undersigned counsel of being unprofessional as well as unprepared. Both allegations are completely false. Yet the court's bias is so deep that the court refused to instruct the jury that the court's declarations was completely wrong on both occasions, and undersigned counsel was neither unprofessional nor unprepared. There's also a YouTube video, January 22, 2024. There's a minute mark for that. Also, March 20th, 2024, and there's another minute mark and another video where we can locate all of the information that's being presented here within this here motion. Now, the court's overly prejudicial and improper conduct towards Mr. Williams and or his counsel, and its refusal to instruct the jury to disregard their impermissible and false allegations, as well as the court's failure to apologize for its baseless claims, proves bias for the state and prejudice against Mr. Williams and / or his counsel. Now, we're not getting what I'm seeing here, a fair trial by no means or by any means necessary. It's just not happening in this case. With all these claims, all this accusation, and to have a judge like Glanville, Cross, and these attorneys, these prosecutors, these DAs, in my opinion, I see definite bias. I see corruption, and I see prosecutorial misconduct coming from, in my opinion, what I call this judicial system in Georgia, specifically this county in this courtroom. I call this a RICO, okay, based on all of the people that's involved, from the district attorney down to the judges. And this is, my opinion. This is not a matter of a fact, but this is just my opinion based off the readings and what I've been witnessing and the length that is taking for this trial to come to some type of a head, okay? With all of the biasness and all of the prosecutorial misconduct, this case should have been out of this courtroom, period, point blank, where anybody that's connected to them should not be presiding over that. And again, that's just my personal opinion. So now, these above few examples raise reasonable questions concerning the court's partial and bias against Mr. Williams and his counsel's efforts to obtain a fair trial and a fair tribunal without prosecutorial misconduct. So I'm wondering at some point, why not just put in a motion to dismiss, have a hearing of dismissal with all of this? Because honestly, I don't even feel like this should even be in trial with all of what's happening and how long it's taken to get this trial to a head. Okay, that's just my another opinion that I have. So anyway, this court's impartiality is objectively questioned and the court must be recused. Absolutely, recuse the whole court system, okay, in this particular jurisdiction. And I don't think nobody wants to pick this case up, to be honest. So, and then they have another example, Johnson versus State. This court has falsely and wrongly accused undersigned counsel of being unprofessional and unprepared in front of the jury. Now that is a huge no-no, and they ought to know the etiquette skills in this courtroom and how to, be professional, especially in front of the jury who is going to be deciding the fate of said individuals. Okay, so neither claim has any modicum of truth. The prosecutor sat silent as the court wrongly and falsely accused undersigned counsel of improper conduct in front of the jury. All prejudicing Mr. Williams, the court has violated its duty of neutrality, impartiality that it was sworn to undertake. See Johnson versus State. Even knowing that the court has falsely accused undersigned counsel of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper, highly prejudicial comments. The conduct shows that the court is biased against Mr. Williams and / or his counsel and favors the state, as no unbiased judge would not correct such a serious misstatement made in front of the jury. The bias of the court is objectively proven, and there's another example on YouTube dated January 22, 2024, and there's a minute mark for all of that, as well as a link to see all of the information that's put in this motion. To date, the court has done absolutely nothing to stop Lawyer Love from continued misrepresentation, abuse of others, and false allegations. Instead, on occasions, the court speaks in generalities and reminds both sides to be professional. See another YouTube dated June the 13th, 2024. There's minute marks as well as a link to that one as well. This is not a both side issue. This is one-sided issue resulting in prejudice to Mr. Williams and a violation of his constitutional rights to a fair trial. And again, this is more, in my opinion, grounds for dismissal with prejudice, so they can never try this again. Okay, Mr. Williams languishes in jail without bond since arrest on May the 9th, 2022. Mr. Williams has been and is being denied his constitutional right to due process, a fair tribunal, and a fair trial based upon prosecutorial misconduct and judicial misconduct. The court has exhibited a pattern of bias in favor of the state and against Mr. Williams and or his counsel, and the court has failed to admonish Lawyer Love to prevent her past and continuous misconduct. This failure to act by the court has emboldened Lawyer Love to persist in engaging in misconduct. And see, this is one thing that Alec Baldwin's trial judge did not allow in her courtroom. When she saw that foul, she questioned that foul, and then in the end, we saw the integrity, and we saw justice be served, as they should have thrown out Alec Baldwin's case. The same way this judge should have been throughout this case, especially with all of this biasness and this prosecutorial misconduct. But see, in order to get away with something like this, there has to be a lot of people involved with working hand in hand, and this is my opinion, okay, working hand in hand to allow all this biasness and all this prosecutorial misconduct to happen on its said watch. Because what we saw in, if you was tuned in to the Alec Baldwin case, you would clearly see that all of the stuff that was caught in that case did not go past that motion in that hearing. That first one was all that the judge needed coming in from Alec Baldwin's defense team, and they laid the foundation. They crossed their T's, they dotted their I's. Every duck was lined up in a row, and they quacked all the way till he was dismissed. And that's the same thing that needs to happen in the Young Thug's trial, because because in the Alec Baldwin's trial, everybody that was involved, and I'm talking about, and this is my opinion, from the district attorney, which we clearly saw, the head honcho, and I'm talking about I can't even quote her name right now, but anyway, her, and then the technician, okay, the forensic technician, down to some of the witnesses, and then, in my opinion, they need to free that girl Hannah Gutierrez as well, because she, in my opinion, is innocent based off of the lack of evidence that they withheld on purpose in that particular trial. Okay, so in this case, you have to have a team of people that's willing to do this. Now, what we saw in Alec Baldwin's case yesterday was the one of the district attorneys resigned right after lunch, because she was trying to communicate with the team, saying, you know what, we just gonna have to dismiss this case. Like, this is the right thing to do based on this information. And not only was the defense withheld from this information, but one of the prosecutors who was fresh on the case, who just got the case in April, she was new to the same information that the defense was new to, as we all who tuned in was new to. So if we're all finding this out, and you're the DA trying this case, and you're finding out some evidence was withheld, the right thing to do was to go ahead and throw it out. But see, she had to withdraw herself to hold her integrity intact, because the others was like, no, 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 we're going to keep on going. If the judge wouldn't have dismissed it, baby, you better know they was about to keep it pushing and to try Alec Baldwin to a conviction, a wrongful conviction. That many times we see often people are being railroaded. There are people that are innocent and they are being wrongfully convicted. And see, this is why I fight for those that are in need of someone to have a voice for them, because they're being silenced. They can't speak, so that's why I do what I do. Now, getting back into this case, so the difference between this case and Alec's case is that judge was not having it. Now, Glanville, and this is my opinion, he has to be in on it, because there's no way that you're threatening a trial defense lawyer to give up information, or you're going to be, held in court's contempt. Okay, and jailed. So you're threatening him publicly and openly while cameras are rolling. We, the people, are watching, we're tuned in, and we are voicing our opinions, and we're using our platforms to do so. Okay, so and again, that's why I feel this should be thrown out. But anyway, the court has effectively joined, and see, he already saying what I'm saying. The court has effectively joined the prosecution team by permitting lawyer love to defy court orders without consequences. Now, if he was a judge of integrity and morals and values, and upholding the law as he was sworn into, then he would have been let this go. Now, I don't know if this is some type of payout, and I'm putting this out as alleged or whatever, because I don't know, but it's just not right what I'm seeing and what you all are seeing, and you all have a voice of an opinion. So anyway, the court has imposed absolutely no sanctions to stop or deter this prosecutorial misconduct. As a result, Mr. Williams has not received a constitutionally mandated fair trial. Okay, and everybody has the right to a fair trial. And because Baldwin could get one, they had to do the right thing. Looks like Young Thug isn't getting one. They need to do the right thing. Okay. Now, as a result, Mr. Williams has not received a constitutionally mandated fair trial, does not have a fair tribunal, and his due process rights have been repeatedly violated because of the prosecutorial and judicial misconduct. Because the state has blatantly violated Mr. Williams' rights, they have goaded Mr. Williams into making motions for mistrial, all of which have been denied. And they're denying these motions constantly, okay? And this is a heavy one because, you know, because still really laid the foundation out. So it makes it so clear that, you know, I don't care how you learn, you should be able to understand exactly what's being said here, okay? So now, all of which has been denied. The above few examples are egregious and cast a dark, ugly stain onto Georgia's justice system. The below further captures the violations of laws that Lawyer, Love, and Hilton and the court display herein. On Monday, June the 10th, 2024, the court, along with lawyers Love and Hilton, engaged in an ex parte meeting with, among other persons, previously sworn witness Mr. Copeland, for whom an order of use immunity has been issued on Friday, June the 7th, 2024. No notice of this ex parte meeting was provided to any attorney for any of the accused on trial. And I mean, they kept all of the accused attorneys out of this, okay? In fact, the accused and their counsel were woefully unaware that this Star Chamber meeting was occurring or had occurred until well after the fact. Mr. Copeland had previously been called to testify on Friday, June the 7th, 2024, asserted his Fifth Amendment rights in front of the jury, and was held in contempt and incarcerated until such time as he agreed to testify pursuant to the order granting use immunity. You can also see the YouTube video on that one. That's dated June the 7th, 2024, and they have the minute mark for that one as well as the link. Once undersigned counsel confronted the court with a motion as to why the court held the impermissible ex parte meeting on Monday, June the 10th, 2024, the court and the prosecutor eventually admitted in open court that this ex parte meeting had in fact occurred on the morning of June the 10th, 2024. The admissions occurred only after undersigned counsel revealed, based upon information and belief, that this impermissible illegal meeting occurred. And so what they're saying here is something happened in that meeting that got Copeland to testify against his will, because Copeland had openly said, I plead the fifth, meaning he does not want to answer no questions and he don't want to be a part of this here said trial. But the courts and the prosecutor had an ex parte meeting, which in my opinion is totally illegal, and they did it without it was illegal because they left all of the counsels out that should have been a part of that meeting if you're going to have a meeting with Copeland. But they deliberately left the counsel out, had this meeting, and then from there we saw Copeland come and start testifying or whatever, but still giving them hell basically, and not really cooperating with them, but trying to cooperate to a minimum. But what they did was they wanted to impeach Mr. Copeland by having him testify, so that way if he said anything that would be impeachable, then he would have been held reliable, okay? And then they would have had something on him to lock him up as well, because with that immunity, it only covers so much, right? Depending on the way they put that contract together, right? So that was why this is a huge issue, because when you have a witness that says, I plead the fifth, and then you got a judge that's locking him up, and then on Monday he come back and he starts singing, not really the way they want him to, it was off tune, but he still sung. It was like they enforced that. So this is what you called a scare tactic, intimidation of a witness to force his hand to come out here and do what they needed him to do so they could try to do that impeachment. But I like how this is put out here, and I don't believe there's a ruling on this yet, so we have to wait and see. Now, one thing for sure and two for certain, what we saw in yesterday's with Alec Baldwin case, that judge heard it right then and there, and she made her decision right then and there. So it do not take long, as we clearly see, to get this type of motion and come back with a decision. So whatever they're conjuring up behind the scenes is still not a good look for the state of Georgia and for this particular said courtroom. Okay. So anyway, so this admission occurred only after undersigned counsel revealed, based upon information and belief, that this impermissible, illegal meeting occurred. And it was illegal because, like I said, it was illegal because all the parties was not there. Undersigned counsel preferred that statements were made to and in Mr. Copeland's presence by the court and or lawyers Love and Hilton, all acting in concert, okay, meaning together, all right? Asserting that attorney Melnick failed to represent Mr. Copeland's interests, and I explaining the amount of time that Mr. Copeland's would be held in custody unless he testifies, as urged by lawyer Love, Hilton, and the court on June the 10th, 2024. The court denied undersigned counsel's request for the transcript of the improper, unconstitutional ex parte meeting, and denied undersigned counsel timely motion for mistrial based upon, including but not limited to, Mr. Williams' federal and Georgia constitutional and statutory rights that included the right to due process, a fair trial, a fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings. Instead, the court held undersigned counsel in contempt and ordered undersigned counsel to spend 20 days in jail despite the assertion of valid privilege in declining to answer the court's demand to reveal the supposed source of the information about the ex parte meeting. Again, that's a scare tactic. That's a threat. This is biased. This is unethical. And this is illegal, in my opinion, of course. In the afternoon of Monday, June the 10th, 2024, the lawyers Love and Hilton sat mute and permitted this travesty of justice to continue. Okay? It's definitely travesty. Later, lawyer Love argued that the ex parte conversation with sworn witness Mr. Copeland was ethical, just, and proper, despite it violating multiple constitutional provisions, judicial, and canons and rules of professional responsibilities. Okay, and there's another said date, June the 10th, 2024, minute marks, and the link. Okay, now, furthermore, Mr. Williams requests a list of persons involved, the topic of same, and a transcript of all of the ex parte meetings, if any, conducted by the court involving anything to do with this case / trial. Additionally, Mr. Williams also moves that any document that is filed under seal be reviewed by a neutral judicial officer to determine whether same needs to be unsealed and shared with Mr. Williams under statute and or constitutional provisions. Wherefore, undersigned counsel respectfully requests that lawyer Love be barred from uttering false allegations or disparaging words towards another. Lawyer Love, conduct herself with professionalism and in full compliance with the Georgia rules of professional responsibility, which governs the conduct of lawyers in the states of Georgia, if able, and a mistrial be declared based upon lawyer Love, lawyer Hilton, and the court's failure to protect the above stated constitutional rights as well as Mr. Williams' rights to be present under Article 1, Section 1, Paragraph X11 of the Paragraph 7 of the Georgia Constitutional, its federal counterparts, the right to confront witnesses, right to a fair tribunal, right to a fair trial, right to due process, right to present a defense and call witnesses. This 10th day of July 2024, this was respected by the attorney Brian Steele. Okay, and that is his motion. And then here is the order granting the defendant Williams' motion in Lamine number 23, filed on July 27th, 2023, after hearing from the parties on or about August 31st, 2023, specifically Brian Steele on behalf of Mr. Williams and representatives from the Fulton County District Attorney's Office on behalf of the state of Georgia. This honorable court hereby grants Mr. Williams' motion in Lamine number 23 concerning the fact that other indicted persons in this case sought or actually retained attorney Brian Steele. This honorable court already held a conflict hearing and denied the state's efforts to remove attorney Steele as Mr. Williams' counsel. Therefore, the prosecution and all witnesses, parties are hereby ordered not to ever mention that attorney Steele represented any other persons in this indictment unless and until same becomes relevant and its first address to this honorable court outside the presence of the jury. This includes any records calls that mentions attorney Steele as a person sought to be hired by any of the accused. Okay. And so they wanted Steele off of this case. That's what this is reading. They was wanting him off. They did not want Steele representing Williams. They was trying to put in a conflict of interest and have him removed because he is a great lawyer. As we can see, he's standing on business. He has integrity. He's a law-abiding attorney. He's doing what he's supposed to do to protect his client's constitutional rights, and the client's due process to fair trial and tribunal trial. Okay, I'm going to read the comment section before we get into the next reading. Hopefully you guys understood what I read. If you have any questions, please feel free to put them in the comment section and I'll answer them as best as I can. I see my girl Karen is in the building. Shout out to you. Thank you. Prissy is in the building. Good evening. Thank you. Thank you. She also says, I don't understand what is going on with prosecutors nowadays. Are you trying to lose the case, job, and disbarred? I think they definitely doing all three. That's what it's looking like. And again, it's not even happening just in Fulton County. We saw it yesterday in Alec Baldwin's case. I'm sure you all know someone who has been wrongfully convicted of something, and it's just wrong when you got people working in these higher places to say just because they don't like a person or they feel a way that they have this power of authority that they're taking advantage of and locking people up. That's why the jailhouses are overcrowded. They're full with people who shouldn't even be in there. And then the things that they are locking them up for many years is definitely not even, it doesn't even match the crime, the time that most people get. And majority of them are brown people, okay? People of color. He needs, let me see, the judge said, nope, not today, dismiss. Exactly, and that was in the Alec Baldwin case, and that's what needs to happen here in this Young Thug's trial, because what we're seeing here is playing out for the world, and if the world is seeing the injustice, if the world has an opinion about this injustice, why is the judge still sitting on the panel and not doing what's in the best interest to protect the integrity of the courts? This is dirty work. He needs a press conference to bring light to this court by the federal government. Yeah, that would be good. It is publicized, but I think, I don't know. It's just something more needs to be done to highlight, the injustice that's happening in this courtroom. And they're so willing and quick to lock the lawyer up. It's just giving Dirty work. Must have dirt on Copeland. I mean, they got something, you know what I mean? Because they really holding his hand behind his back and enforcing him to testify pretty much as we can see. And if he can speak, trust me, against his will, okay? And I'll just go ahead and jump out there and say it on his behalf, okay? And it ain't on his behalf because he's not authorizing me to say this. I don't know him, never had a conversation with him. But yeah, I like to cover a lot of what he does. He is funny and he's made himself an internet sensation. So shout out to Woody, or how you saying it, Woody. He has a specific way he like people to say his name. If you saying it incorrectly, he gonna call you out on it. All right. So hopefully I said it right. Now, let me remove this off my screen for 2.2 seconds so that I can pull up the next one and get into the readings of that one. All right. Let me go here. Boom and boom. I don't know how long this next reading gonna be, but this is gonna be the response from the DA. Okay, so let's see. We just did this one. Alrighty. Okay. And I need to get this next file out. Okay, I got it. Boom. Let's go out of there. Take me here. Open. Okay, gotta be this one. Let's see. Let's open this one up. 7924. How many pages is this one? Can we exit? This might be the one I'm looking for. I think it is. Okay, this is the amended one. So hold on, y'all. Gotta pull the right one up. Because this is the amended one right here. Must have dirt on Copeland. Yeah, they got something. They definitely got something. Okay. And so let's see. I'm sorry. I know y'all probably was looking for my pretty face tonight, but baby, I'm tired. I got my bonnet on and I refuse to come on social media with a bonnet. It ain't gonna happen today. It ain't gonna happen tomorrow. So when you see me, you see me, okay? I know most of y'all just want to see something. Let's see. The undersigned counsel. Okay. Got that one. Boom. Let's go here. Let's this one. That's that. Okay, so I got 7, 9, 17. Here we go. Let's see which one. Okay, so here's the list, okay? Let's go over this here list. Let me save this so I can pull this up a different way. This is only 5 pages, so this was really short. This is the amended witness list. Witnesses. Because I think the other one is a longer reading, so I don't know if y'all got that type of time, and I don't know if I got it either. Okay? Because I'm kind of late coming in, so we just got to pick up where we at or whatever it is, what it is. All right, let me share my screen. Where did my screen share just go? Give me a second. There we go. All right, boom. So, in the Superior Court of Fulton County, State of Georgia versus Jeffrey Williams, the defendant Jeffrey, you good. I just hopped out the shower and that's it. Right, girl. Okay. I've been getting my beauty rest on. I got to stay well rested because social media don't pay me enough money to come on here like half the people do. Okay, I gave y'all my whole Friday yesterday covering that Alec Baldwin trial because I missed day 2. But next time I'll just be well prepared to move forward. Okay, I think I'm gonna have to reinstate my my account so that I can get these documents right when they come out. Okay. Let's see. Okay, y'all can see this. So defendant Williams' 8th amendment list of witnesses comes now. Mr. Jeffrey Williams, by and through undersigned counsel and for. So they got the whole witness list. Okay, this witness list in the above reference case. And let's just see how many people they got on the list. I'm not going to read their names out. I'm sure you guys heard this on multiple platforms. And I'm just the last to come in. But you know what? God said the first should be last and the last should be first. And I trust my Father because I know He can do exceedingly and abundantly above all. So this is pretty much just the witness list. So they have, looks like 58 Woo, witnesses. Where? Let me see. Some of the people that was on there. And Jeffrey Williams Sr., which is the daddy, he's on there as a witness. And I wonder if they put them in the order of which they're going to be called in. You know, because this trial, oh, it's going to be a minute. All right, so let me get to the bottom of this one. And any and all co-defendants in the above reference indictments, and any and all witnesses named in the state witness list, as well as any and all witnesses named in the co-defendants witness list, this 10th day of July. Okay, so let's see. Okay, so that's a long little list. I mean, my God, but that's not. I don't know. That's just the defense's witness list. Let's see. State of Georgia, the defendant Jeffrey Williams, Eighth Amendment. Yeah, this is his list. This is Young Thug's witness list of the people who he's going to be calling. Let's see who on that list though. Were they gonna call Copeland to this though? I wonder what they're gonna call. Let me see how I say his name. He said, "What? How you say my name?" They said, "Woody, Woody, Woody." It's Woody, not Woody. It's Woody, Woody, like Woody. All right, let's see. Is he on this list? Cell phone experts. They call him the detective. Judge Earl, Damien Detention, Doretha. I don't recognize any. I wouldn't know that these people know it, but I'm just being to see. Let's see. Investigators, experts. Mr. Kelvin, Jeffrey Williams, Lawrence Zimmerman. Okay, well, that's that list. Let me get off of this page and let me take this off my screen for a second because I don't want to be sharing all of what I have behind this wall. Okay, now let's see which one is this. State of Georgia supplemental motion to recuse. Judge Glam. Okay, so we have the motion to recuse. Let me see how many pages. Ooh, 233 pages will not be read tonight. Okay, I'm so sorry. I won't be doing that tonight. Ooh. And then the response is 81 pages. Let me see. State's response. This is the state response, you all. Let's get through some of this. I ain't fit to promise y'all all of my night, but even though I ain't got nothing to do because I did what I had to do all day and rested well. Where's my screen share at? Hold on, y'all. This is a lot. Oh. Where's my screen share? Where did you go? Come on. Alright. Screen share. Alright, here we go. Boom. Wait. Where's my screen share? Way down there. Come on, let's put this up here somewhere. Oh. They playing games. I think they're trying to shadow ban me too, y'all. They definitely working on the shadow banning. Why are they saying unlock my screen? They're not recommending my my platform. So it is what it is. We just got to keep working hard, y'all. We got to go work a little harder. All right, so here we go. This is the state's response. Make sure everybody, if you can, whether you come in this live now or you catch this live on the playback, please hit that like button. If you don't stay, hit it on your way out. If you don't, hit it on your way in. And if you're not subscribed to the channel and you like this content, you want to see more, then please subscribe to this channel and turn that post bell notification on. It's important to select all so you don't get some when I go live. You'll know when I'm live every time by hitting that bell notification and selecting all. So let's get into the state's response, okay? See how much time I got tonight because I'm a quick reader. I really don't need to take that much time. Only thing I do have to do is blow it up because y'all know I can't see and I was struggling trying to read that last one. All right, let's see. All right, let's get into this. All right, so this is the introduction. Midway through this now months-long trial, defendant Jeffrey Williams and defendant DeMonte Kendrick have each filed a motion to recuse Chief Judge Earl Glanville hereinafter motions, and defendant has filed a supplemental to the motions hereinafter supplement. The state recognized that Chief Judge Glanville has reassigned the motion and that it has been properly reassigned to this honorable court. But the state respectfully submits that at the time of reassignment, Chief Judge Glanville did not make the three requisite determinations. 1, whether the motion was timely filed. 2, whether any affidavit made in support of the motion is legally sufficient. And 3, whether if some or all of the facts set forth in the affidavit are true, recusal is authorized. Accordingly, it fails to this honorable court to make those determinations. So when I'm starting to read this and I'm giving y'all my thoughts of my readings as I'm reading this, it's given, even whoever this person that's writing this motion is given, they all working together, okay? Because they're this is corrupt at a high level, and for it to happen in front of our faces, they're playing in our faces like we don't see what we see, and I can't unsee it because they not like us. Anyway, accordingly, it falls to this honorable court to make those determinations as set forth below. Wait, where did I lose my thought? Where was I at? As set forth below, though defendants' motions and supplements are in part timely, and the affidavit are in part timely. So that means half of it is and half of it ain't. So what is it? Either it is or it ain't. Okay, how you gonna say in part timely? Like, come on now. And the affidavits in support of defendants' motion and supplement are in part legally sufficient. None of the facts set forth in defendant's affidavit, even if assumed to be true, would authorize recusal. So even if you assumed it was true, it's still, they're saying it does not authorize a recusal. I disagree, and that's my personal opinion. The defendant's motions and supplementals should therefore both be denied. So they're really fighting to keep this case going. They're adamant about denying this bond and asking for the courts to deny this bond, and we have to wait to see how this is going to be ruled. I think this should be ruled granted, because this should not be denied. They need to grant the recusal or a fair trial, or just throw the whole doggone case away, in my opinion. Okay, just dismiss it with prejudice at this point, because there's too much happening that's illegal that's happening. Okay, so the calling of state's witnesses, let's listen to their justification, because they're justifying their wrongdoings in this here response. Okay, so Kenneth Copeland on June 6, 2024, in response to an inquiry from counsel for the defendants in this case, the state announced that Kenneth Copeland would be the state's next witness and would be called to testify on June 7, 2024, right? We saw that play out. And we saw what he did on the stand. He pled the fifth. Anyway, after the announcement, the state received an email from John Melnick claiming to represent Kenneth Copeland and instructing the state to cease communications with Mr. Copeland, and that Mr. Copeland would be asserting his Fifth Amendment. So they're violating Mr. Copeland, because if he has counsel, the courts cannot communicate with Mr. Copeland because he is being represented. So if anybody know y'all rights and you are getting arrested and they tell you have the right to have a counsel, if you do not have one will appoint one for you. And the moment you say you got counsel, the conversation is cut short right then and there. Can't say nothing else because we got to talk to their lawyer. So the fact that they are aware that he had representation, and they're saying claim as if it's not a matter of a fact. Claiming means he's saying something but without truth to it, because they didn't put this in there as John Melnick is representing Kenneth Copeland. They said John Melnick is claiming. Okay, so I want y'all to catch the words, because they're word playing with us and they're not saying this to the people that don't understand the legal terminology, because what we think word of claiming is not the same when it comes to the court of the law. Just want to put that out there. Okay, so anywho, let me get back into this. All right, so claiming to represent Kenneth Copeland and instructing the state to cease communication with Mr. Copeland and that Mr. Copeland would be asserting his Fifth Amendment, right? Privilege if called to testify on June the 7th. So they were well aware of this. Perplexingly, given that Mr. Copeland was being called to testify against Jeffrey Williams and Shannon Stillwell, who are represented respectfully by Brian Steele and Max Short. Melnick copied Brian Steele and Max Short on his communication with the state regarding Mr. Copeland's intentions not to testify. Okay, so in preparations for trial, Deputy Hilton, along with her investigator, okay, and that was a dirty investigator in the Alec Baldwin case, okay, and forensic techs and stuff. There was a lot of players in that case that was trying to take Baldwin down, but thank God he had good representation, just like Young Thug does in this matter. Had met with Mr. Copeland on multiple occasions. I'm talking about Hilton and her investigation met with Mr. Copeland on multiple occasions, and at no time did Mr. Copeland state an intention to plead the Fifth or say that he was represented by Melnick. Then if that's the case, where's that recorded conversation? Because every conversation that they had with Mr. Copeland should have been recorded and documented. So they should be able to present that evidence and not just conjure up amongst each other. Well, you got my back, I got your back. You know, if I say it, you say it, we said it, it's going to stand test of time. No, present evidence, because right now it's not been presented. Okay. So anywho, they had this conversation with Mr. Copeland, and they said that, and he never stated that he was going to plead the Fifth, right? Or say that he was represented by Mr. Melnick. This is what they're claiming, right? Nevertheless, okay, yes, it is something, not never, but okay. Or say that, wait, where did I go? Went up too far. Hold on, y'all. Now I gotta start highlighting. Hold on. Okay, here we go. Nevertheless, after receiving Mr. Melnick's email, Deputy Hilton ceased communication with Mr. Copeland until June the 7th, 2024, pursuant to OCGA. There's a penal code 24-5-507. After receiving Mr. Melnick's email, the state presented to Chief Judge Glanville a motion to compel the testimony of Kenneth Copeland, extending immunity to Mr. Copeland for his testimony, and to hold Mr. Copeland in contempt should Mr. Copeland refuse to testify after being ordered to do so by the court after being granted immunity. The court issued an order granting the state's motion. Okay, so this is how they justify their wrongdoings, because obviously they got people put in place to support everything that they say and do, whether it's a foul or just plain out misconduct, allegedly. On June the 7th, 2024, after court was called to order Mr. Melnick appear before the court and inform the court that Kenneth Copeland would be asserting a Fifth Amendment privilege against self-incrimination in the presence of each defendant currently on trial and each of their respective attorneys. Chief Judge Glanville called Mr. Copeland to the stand and explained to Mr. Copeland that the state had sought and been granted an order of the courts pursuant to the OCGA 24-5-507, directing Mr. Copeland to testify and extending immunity for Mr. Copeland. So now they're trying to extend it for him to testify. Okay. Compelled testimony. Extending immunity for Mr. Copeland's compelled testimony. Chief Judge Glanville further explained to Mr. Copeland in the presence of every defendant currently on trial and each of their respective attorneys that should Mr. Copeland refuse to testify, he will be held in contempt of court and jailed until he purged himself of the contempt by testifying in court. Basically, until he had his hands tied against his back. Okay, that's how I'm just going to say it. I'm going to call it the way it is. Mr. Copeland, which is AKA YSL Wody, he has his hands tied behind his back. He was forced to come in and testify when we clearly heard him plead the Fifth. Okay, so anyway, Mr. Copeland therefore stated his intentions to testify, and Mr. Melnick looked toward Mr. Steele and Mr. Schwartz and shrugged his shoulders. After motions hearing, the court recessed for lunch. During the lunch hour, Mr. Melnick spoke with counsel for the defendants, but at no time attempted to communicate with the state. After lunch, wait. Okay. After lunch, the jury was called in and Mr. Copeland took the stand. Mr. Copeland cheekily answered a few questions. And when asked his age and years, Mr. Copeland responded, "I plead the fifth." The court allowed no further questioning by the state and immediately excused the jury, held Mr. Copeland in contempt, and ordered Mr. Copeland into custody. So they're trying to justify why they held him into contempt and locked him up the way they did, okay? They're trying to make their wrongs right. In open court, in the presence of all of the defendants currently on trial and in the presence of each defendant's respective attorneys, Chief Judge Glanville informed Mr. Copeland and Mr. Melnick that he would bring Mr. Copeland back into court on Monday, June the 10th, 2024, to allow Mr. Copeland to purge himself of his contempt by testifying. Mr. Melnick announced that he was going on vacation, would in no way be present on that Monday, and would appoint stand-in counsel Kayla Bumpus. That's how she came into play, to represent Mr. Copeland in court the following Monday when he decided to purge himself and go ahead and take that stand. So on B, the June 10th, 2024 meeting regarding contempt proceedings initiated against Kenneth Copeland upon motions of the state, attended by counsel for Kenneth Copeland, attorneys for the state, Kenneth Copeland, and the Honorable Chief Judge Glanville. On Monday morning, prior to the state Monday morning prior to the start of court, the state requested from the court an in-chambers meeting with counsel for Kenneth Copeland, the court, and attorney for the state to discuss the contempt proceedings. So they're trying to make it appear as if the what they was discussing in that secret ex parte was of the contempt proceedings, right, that initiated against Mr. Copeland upon the state's motion. The court granted the state's request, and upon being directed to do so by the court reporter made a record of the entire meeting. Present during the meeting were CDDA Love, attorney Kayla Bumpus, investigators for the state, and the Honorable Chief Judge Glanville, and later Kenneth Copeland and DDA Hilton. Matters addressed during the meeting concerned only the contempt proceedings against Mr. Copeland. And the topics addressed, including topics Mr. Copeland's rights and representation as it relates to the proceedings, Mr. Copeland's obligations under OCGA 245507, and answers to questions posed by Mr. Copeland regarding matters related to OCGA 5507, such as the distinction between purging oneself of contempt as addressed by OCGA 245507 and perjury as prohibited by OCGA 5507. With the exertion of the times where Mr. Copeland was afforded an opportunity to speak with Mrs. Bumpus alone. The entire meeting was taken down by the court's reporter. Brian Steele's defiance of the court's commands and subsequent contempt ruling, because Mr. Steele, which is Young Thug's lawyer, felt he should have been present in that meeting as well with Kayla, even though she was representing Wody at that time. Then he should have been there too, and any other counsel that's got their clients in this matter should have been a participant. So after the meeting regarding Mr. Copeland's contempt, and see, they know who leaked this information because they're working with each other. There's no way you're going to tell me who leaked this information unless you all are in cahoots with each other and for a fact that X, Y, and Z ain't said nothing. So it had to come from A, B, and C. Okay, just want to break that down for y'all. Now, the entire meeting was taken down by the court's reporter. Brian Steele's defiance of the court's commands, and they said he was defiant, y'all. How is he being defiant to the court's commands and subsequent they contempt the ruling on him, right? So after the meeting regarding Mr. Copeland's contempt and obligations under the OCGA 245507, Brian Steele stood in open court and demanded a mistrial, right? As he loudly and repeatedly hurled at the Chief Judge Glanville accusations of misconduct. Most disturbingly, after accusing the court of illegal activity, Mr. Steele repeatedly disobeyed the Chief Judge Glanville's command to reveal Mr. Steele's source of information regarding in-chamber matters. After Mr. Steele refused to comply with the court's instructions, the court held Mr. Steele in contempt of court after defiantly and repeatedly disobeying the court and being held in contempt of court. Brian Steele filed the motion and supplement, argument, and citation of authority. No facts set forth in defiance motion or supplement authorities, the recusal of Chief Judge Glanville. Now I'm going to stick myself out here a little bit further and just say this. Regardless of whatever they trying to justify in this here motion to deny Brian Steele, what I will say is X this out. Let's get to Y and Z about what Brian Steele has put in claims that happened prior to this, and I'm putting this in quotations, y'all, this defiant court contempt, as they are saying, okay? So now, they need to focus on that alone, okay? And then they wouldn't even have to respond to this if they do the right thing when it comes to that. And that's my thoughts. Arguments and citation of authority. No fact set forth in defendant's motion or supplement authority authorizes the recusal of Chief Judge Glanville. Look how they're fighting tooth and nail to keep, in my opinion, and this is just my opinion, this is not a fact, a dirty judge, a corrupt judge on this case to do the corrupt thing, which is regardless of whatever the prosecution do, we're just going to dust that under the rug and we're going to keep the court's proceeding moving to try their hardest to hurry up and get to a head so the jury can make a decision and try to find Young Thug and the rest guilty. Okay, that's what it's given. I mean, because what else? There's no other justifications for what's happening here. So anyway, to warrant disqualifications of a trial judge, the affidavit supporting the recusal motion must give fair support to the charge of a bent of mind that may prevent or impede impartiality of judgment. To be disqualifying, the alleged bias must stem from, and he says alleged, it's the words for me, must stem from an extra judicial. I don't know why I'm not saying that word right tonight, y'all. Forgive my lack of of wording. I don't know if I'm just tired or what. Judicial source and result in an opinion on the merits on some basis other than what the judge learned from his participations in the case. Emphasis are added. There is a presumption that a trial judge, acting as a public official, faithfully and lawfully performs the duties devolving upon him. Determining whether an affidavit supporting a motion to recuse is legally sufficient and whether the facts asserted authorize recusal present questions of law. Here, with the exceptions of the defendant Williams' untimely allegation regarding a single instance where Mr. Steele was chided by the courts for not being prepared. Defendant's motions and the supplements are based entirely, look how they emphasize it entirely, like with big dark bold letters, on the defendant's assertions regarding the June 10th, 2024 meeting regarding the contempt proceedings against Kenneth Copeland and actions taken by Chief Judge Glanville after Mr. Steele defiantly refused to comply with the court's repeated request to provide the court with information. Now, the court is asking for Brian Steele to give up his source. Why was that so important about how he got that information? Why are they solely focusing on that key point right there rather than the fact that they had this secret meeting outside of Brian Steele? So what they're doing is trying to make it hard for him, and they're trying to justify their wrongdoings, and they're sticking it to him. Okay? So anyway, Georgia Code of Judicial Conduct 2.9 regarding ex parte communications provides that judges shall accord to every person who has a legal interest in a proceedings, or that person's lawyer the right to be heard according to law. Emphasis are added here as well. However, no defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on motions of the states involving Kenneth Copeland's refusal to testify. So let's read that again. No defendant on trial in this case had or has any legal interest in or any standing to be involved in the state's motion to compel the testimony of Kenneth Copeland or any subsequent contempt proceedings initiated on motion of the state involving Kenneth Copeland's refusal to testify. How do they feel? I don't get how they feel that that's accurate. Since no defendant in this case had a right to be present. And see, that's how they're trying to justify. They're trying to make it seem like that no defendant that's on this case, like Young Thug or any of them, had any right to be at that particular meeting with Copeland because the meeting was only about him being in contempt. Okay, but again, that's problematic. And anybody that's blind can see that that's problematic, because I don't care if it's a contempt. The fact that he was on that stand, he said he pled the fifth publicly and openly through the courts in front of the defendants, their counsel, and the juror. You telling me that the attorneys that's representing their clients is not allowed to be there? You got to be kidding me. Okay, and that's just, again, my opinion, right? So anyway, Case had a right to be present at the June 10, 2024 in Chambers meeting with Kenneth Copeland and his counsel regarding the contempt proceedings against Kenneth Copeland. The fact of the meeting provides no grounds for recusal of Chief Judge Glanville. Respectfully submitted this 10th day of July 2024. This is Chief Deputy District Attorney of the Fulton County, Adrienne L. Love. She's wrote this out pretty much, and she's doing her best to try to defend Judge Glanville and keep him in the now on this here said trial. Okay, that they are doing, and I'll say that all of Kenneth Copeland and them is trying to get them off. So I don't think I have to even read any further, because everything else in this is actually going to be exhibits. So they have a lot of excerpts in this, and the excerpts are pretty much what you guys are going to see here. So if you want to go fast, go alone. If you want to go far, go together. You know, different little proverbs. I don't know where this is coming from. Let me see. This message is from an external sender, and this is from Kenneth Copeland. Proposed bond order. So this is June 7, 2024. My concerns is for my client. Had I been involved, I would have demanded a much more specific immunity deal. You need him much more than he needs you. Okay, because they need him. He don't need them. You've put him in a terrible position where you know his life is in danger, whether in custody or on the street. He's a marked man from this point forward. Go F yourself if you think I'm doing anything besides protecting my client. Okay, and that came in on Friday, June the 7th, 2024. Love, Adrienne, is your concern for your client or for Mr. Steele and Mr. Sharts. Okay, so and this is crazy that his life has been put in danger based on the court's decision to enforce him to purge himself to testify. They made him do this. That he basically had to unalive himself in order to come in to be released out of custody, and to come on that stand and say he was grown, to say, I don't know what you're talking about, I don't recall. He had to do all of that. And in order for them to release any of those pre-recorded, conversations that he had with the investigators in those rooms, they was able to present that because they managed to get him to purge himself. So they did a lot of stuff violating Mr. Copeland's rights, his due process, and a fair response to say, you know what, I want to plead the fifth. He had that right to do, but they're saying that he didn't have that right under the immunity. So this was an involuntarily misconduct on Mr. Copeland's part by saying, he pled the fifth. But see, they're trying to say, they're justifying, well, they wasn't aware, no one knew, and that they had this conversation, and he never mentioned having XYZ as his lawyer. But I call BS. And this came in on June the 7th. Now, my question is, now, Mr. Copeland, I don't know. I guess he must have. I don't know, when did he hire Melnick? That would be one of my questions. Is when did he hire Melnick? Because did he hire Melnick prior to him testifying? Did he hire him because he found out he had to testify, and then he had a lawyer advise him to not, say anything further and just plead the fifth? Like, that's a question that I don't know. If you guys have that answer, leave the comments in the comment section. If you don't catch this live, then go ahead and leave that comment in the comment section, and I'll be able to take a look at it at that point. So then, because this is what I'm seeing from the attorney that was representing Copeland and was sent to Hilton and Love. That's what I see here, okay? And this is another one, subject Kenneth Copeland proposed bond order. Here is a communication between myself and Mrs. Love, which pertains directly to the YSL case. And this is dated March 3rd, 2023. Who is this coming from? This is, he been on. This is they already addressed him. Here it is right here to attorney Melnick. So he's been on the case. So it's not that he just got there. So I don't understand, why did they feel he didn't have representation? So this to me is a paper trail to show that he did. Let's see. Kenneth Copeland proposed bond order. Okay, he got his lawyer tagged in that. They're communicating amongst each other. So who else is on this thread? You got, this is coming in from Adrian Love to Wodie's attorney, to who else? Rosa, Sheila, okay, Fulton County government. Okay, let's see. Regarding Copeland, this is his bond thing. Good morning, Mrs. Rosser. The state asks that the defendant be required to sign the conditions in front of a notary or a sheriff official so that we can enforce the conditions upon his release, since he was not apprised by the court in person. They put Copeland's life in danger. He is definitely a marked man, and you can thank the government for that. So Sheila is a litigation manager. This was directed to the Honorable Judge Page Reese Whitaker, Superior Court. Let's see, March 1st, 2023. Also tagged in this is Copeland's lawyer. Okay, forwarded. Kenneth Copeland proposed bond order. So this is his bond order. Good evening, John. I have attached a version of the bond order, both with and without the curfew that the judge ordered. In order to facilitate the expeditious signing of an order, please present them both to your client. For his signature so that we can get an order signed, even if the court insists on her curfew restrictions. Have a good evening. Okay. Let's see. This is some more. This is, like I said, we read it all. This is just the excerpts. I'm just kind of like going through these excerpts. Ex parte motion for order to compel testimony necessary to the public interest. So this is their motion to compel it. Let's see, the ex parte pursuant to OCGA 245507. The state of Georgia, by and through Fannie T. Willis, District Attorney, and they speak so much of her, my goodness, of the Atlanta Judicial Circuit, and the undersigned Chief Deputy District Attorney Love. Like I said, in my opinion, these are the key players that's pulling these strings. You got Fannie Willis' name all in this, and of course, because she's the Georgia District Attorney, right? Then you got, she's the Fannie Williams is the District Attorney of the Atlanta Judicial Circuit, and the undersigned Chief Deputy District Attorney is Adrian Love. So that's two conflicts, in my opinion. Hereby moves this honorable court to compel a material witness, which is Kenneth Cole, to provide testimony in the trial of the above styled case. Further, in the event that said witness refuses to testify after being ordered to do so by his honorable court, the state moves this honorable court to hold said witness in contempt of court pursuant to the OCGA 245-507B and have said witness committed to the Fulton County Jail until such time as the witnesses purge himself of contempt. By testifying as ordered by this honorable court in support of this motion, the state shows this honorable court the following. Well, I'm going to say this. Well, let me just finish this reading and I'm going to say this. On January 10, 2015, Donovan Thomas Jr. was gunned down and murked at 330 McDaniel Street in Atlanta, Georgia. Reginald Hendricks and 14-year-old Cordelius Sanders were also struck by those strays during the shooting. The Fulton County Medical Examiner's Office determined that Thomas Jr.'s cause of death was gunshot wounds to the torso and determined that his manner of unaliving was homicide. Firearm evidence recovered from Thomas Jr.'s body and from the scene where Thomas Jr. was gunned down, 330 McDaniel Street in Atlanta, Georgia, revealed that a 7.62 rifle and at least one handgun were used in the unaliving of Thomas Jr. and the shooting of Hendricks and Sanders. Surveillance footage recovered from businesses in the area where the shooting occurred revealed that Thomas Jr., Hendricks, and Sanders were assailed by gunfire that originated from the sunroof and possibly windowed of a passing vehicle as the vehicle traveled west on McDaniel Street at around 7:22 p.m. on Sunday, January 10th, 2015. So they're trying to solve a homicide from 2015 and 2024. That's what I'm getting here, okay? In the early mornings, hours following Thomas Jr.'s unaliving, Kenneth Copeland appeared at the Atlanta Police Department headquarters building and requested a meeting with police to report his whereabouts during the time of the unaliving and to report that his family was being targeted by people that, according to Copeland, apparently believed that Copeland was responsible for the unaliving of Thomas Jr. And I believe Thomas Jr., I'm not sure if this is supposed to be Peanut, because I don't know Peanut's real name yet until we get there, but yeah. In the days and weeks and months following Thomas Jr.'s unaliving, Copeland gave 6 recorded statements to law enforcement, one of which was over 9 hours long, detailing Copeland's involvement with the criminal street gang YSL and statements of YSL co-conspirators about the involvement of YSL members in the unaliving of Thomas Jr. and other criminal activities. Copeland gave a detailed account of the events that led up to the unaliving of Thomas Jr., as well as his own involvement in said events and of the events and acts committed by Copeland and other YSL members in the months following Thomas Jr.'s unaliving. Phone records of Copeland and other YSL members corroborated the statements that Copeland gave to the police. Statements made by YSL co-conspirators also corroborated the statements that Copeland gave to the police. Based in part upon the statements that Copeland gave to the police, 5 YSL members were indicted for the unaliving of Donovan Thomas Jr. and 28 members of YSL were indicted for violations of the Racketeering Influence and Corrupt Organization Act. In the judgment of the Honorable Fannie T. Willis, District Attorneys of the Atlanta Judicial Circuit, this testimony of Kenneth Copeland is necessary to the public interest, okay? So hopefully this is explanatory as to why they were so adamant that Copeland needs to testify. They need him to testify because he came in there and gave statements the same day that this here Thomas was unalived. So when he went in there voluntarily and gave these statements, it most likely when you give a statement like this, and I'm just giving y'all my honest opinion here, so hopefully y'all bear with me. They tell you, you may have to come and testify in court. Okay, so now in testifying in court, you will be given an immunity. See, a lot of this stuff I did not know. Like I said, I'm coming in last. So coming in last, I got to review everything. I can't come in here last and not know what is in front of me right now that I'm reading to the viewers. Okay, so with this being said, now I understand a little bit better why they needed him to testify. Now, and that's fine and dandy that they, he came in there and gave his own voluntary statement and And from the sounds of what I just read, he is responsible for the indictment of this case that we're watching play out today. Okay. And that's just me on the outside looking in. I ain't taking a side. I'm just calling it as it is. Like it or love it, hate it, don't make no difference to me. It's out here now. Boom. So what the problem that I have is that, and see, now I see why they're so adamant about not wanting to throw this case out and why they're not recusing themselves, okay? Contrary to the beliefs of all of the information that's out here, this to me would make sense because he came in there and he gave his voluntarily statements, several of them, and they have them all recorded. So anytime you give statements like that, you are told you do have to come and testify. So now they giving him an immunity deal. He thought, oh, I got an immunity deal and it's been signed off. So what I'm going to do is I'm going to play with the people and I'm going to play in their face. So by him playing in their face, he decided to plead the fifth. Now, this deal with the immunity, I don't know when it was said and dated, but obviously me knowing what I know about the law, he was going to have to testify. He wasn't getting out of testifying. I can tell you that right now. So all the pleading of the fifth and coming in there and acting slow and being special ed and doing the fool and being funny and getting his internet sensation on, he still had to do this. He signed up for this when he went in there and volunteered that information because he was feared for his life because the rumor had it that he was responsible for unaliving the person that I said his name was, and I can't even give you that boy name. My bad. I'm sorry. Let me go back up a notch. Okay, hold on. What is his name? I just said it. Yeah. Okay, so he put himself in this. I'm sorry, y'all, but Kenneth Copeland put himself in this. Okay, something that I did not really know all of the ins and outs to. So this is why it's very important before we pick a side, we get all the information and all the facts so that we know what we talking about when we get to talking. You don't want to come in here and don't know what you talking about. All right. So anyway, so the phone records so they basically saying the statement that he gave them several times, they was able to corroborate those statements that he gave to the police. All this information that he gave them is why this case is happening today. So him, and I said it when he was on the stand, not knowing half of what I'm reading right now. I was like, he throwing the case. If y'all go check out anything that I've said in this that I have been reporting on since I have been reporting, you will see my trend is the same. Okay, don't change. Now, let's get more further into this. And I know a lot of people ain't gonna like this, and I'm sorry, but it is what it is. I gotta call a spade a spade. Okay, so now, and he has the right to, feel away, and say, you know what, I don't want to go in there and I don't want to repeat what I said in that said meeting. I want to come in here and this is what I want to say now, and make it all, clouded so that way the jury don't know what to believe at this point. Okay, but I'm gonna be honest with y'all. Whatever he told them, they did their research. They was able to confirm it. And when they confirmed it, baby, that's how this trial is why it is today. Okay. Wow, this is serious because like I said, they have so much on it to pursue this trial, but I feel even without him getting on the stand and testifying, they still could have used, and I don't know if they could have or they could not, so don't let me not say it like that, like it's a matter of a fact, because this is just my opinion moving forward. If they could have used his statement, his pre-recorded statements against the individuals, and I'm going to tell you, I think not, and the reason I think not is because they still have to come and testify from what I do know legally. Because if somebody make a claim against you, you have the right to face your accuser. So he would have to come and testify everything he said in those recorded statements. He would have to come and testify that up on that stand. And again, he had a change of mind. He had a change of heart. And he came in there and he did what he did. And now he's an internet sensation. And everybody loves Wody. Okay. So anyway, so the forfeiture for any perjury, and then they wanted to purge him. So if there was perjury, they wanted to get him on that, and they needed to impeach him. Okay, so it's just so he's in the hard place, to be honest. So that's why his hands are tied against his back right now, and he's not being freed from these people, is because he still has an obligation to fulfill, and he really failed fulfilling it the way he testified. Okay, so it was hurtful to the prosecution's case, and the prosecution don't like to be made a fool of, because they have this high conviction rate, and they would not have this high conviction rate if it had not been for him for this trial. So one way or another, Kenneth is in a situation. His life is at risk. He's in danger. Every move he make, it's not a good look for him. But see, nothing can happen to him, and this is just my opinion again moving forward, because he is such a value to this case. This is why he's so extremely valuable, because of what he did to get this case even jump started. Okay, by going in there, he was in fear. Somebody said he's the one that did that to the person who I just said, and I forgot his name, Thomas. Okay, he's the person that they're claiming. Well, the streets said it. I ain't gonna say the people. The streets is out there talking, and the streets is saying that Kenneth is responsible for unaliving Thomas. Okay, and so and he felt the heat. He felt his family was in danger. And so he ran down there to the police station and said, hey, my life is in danger. People are saying that I did X, Y, and Z. And in the time he's saying that they were saying that, the investigators had him in there. They felt like he was a weak link. And then him being a weak link to the prosecution, but a strong case to the prosecution, but a weak link to the streets is what I'm trying to say. They felt that he was a weak link to the streets, but they felt he was strong for the prosecution. So that's when they started, and I'm just saying alleged, but really not, because it's right here in our faces, working with him coming in there on multiple occasions, talking to them people, for safety purposes, but then at the same breath, not wanting to leave the state because he felt like, he didn't want to be looked at as what they're titling him today, quote unquote snitch. Okay. Kenneth Copeland has been suspended. Hold on, let's get more into this. Copeland has been Copeland has been subpoenaed to testify in the above styled case. Copeland is the next witness scheduled to testify in this case on June the 7th, 2024. So, again, he already had that one lawyer. I just don't know the lack of communication where he wasn't aware that he was going to be testifying, but found out this is when. And I think it got real for him, in my opinion. Okay, nobody wants to be on TV pointing out nobody and being put out like that. And I believe if they didn't have Alec Baldwin case public, they might have would have gotten away with it. But because the people was watching Alec's case, they couldn't get away with what they was trying to do in his case. Okay, and they need to free Hannah Gutierrez, because that left out evidence caused her to be convicted for 18 months in her trial. Okay, so anyway, back over here to this one. On June 4th, 2024 and June 5th, 2024, investigators with the officers of the Fulton County District Attorney coordinated and arranged with Kenneth Copeland to provide Copeland's transportation to court on Friday, June the 7th, 2024. However, on Thursday, June 6, 2024, after an encounter with the defense team members and members of the Fulton County District Attorney's Office, Copeland stated to an investigator and to an attorney with the Office of the Fulton County District Attorney that Copeland may attempt to plead the fifth in order to avoid testifying against members of YSL. And see what happened, in my opinion, yeah, he definitely got cold feet, but it probably would have been in his best interest had he not eluded the investigators and the attorneys of what he was going to attempt to do in court. And maybe it wouldn't have been a big ordeal about him pleading the fifth, because they wouldn't have had no knowledge. But I don't know. But either way it goes, he still, decided to not want to testify against them, but then it's like cause see what is giving, and I gotta be honest with y'all again, what is giving is Copeland played games with the district attorney's office. He played games with with the immunity. He took advantage of getting this immunity so that way they could not, you know, charge him with anything. Whatever he says and testifies against, they can't use it against him in a future trial or something. Even if he was to come in there and acknowledge X, Y, and Z, they wouldn't. He had an immunity deal, but his immunity deal did not have him pleading the fifth in there. His immunity deal was obviously, and I don't know it, I'm just speaking off of what I'm reading here, is that his immunity deal had to consist with him testifying. Okay? That's the deal, in my opinion, that they would have given him. I don't see them giving him an immunity deal where he's going to plead the fifth when he's such a value to this case, because had he not went in there intimidated by the streets saying that he done something to Mr. Thomas that he claimed he did not, then he wouldn't, this would not be today. So he's trying to right his wrong, but he's trying to right his wrong at the court's discretions, if that makes sense to the viewers. He's trying to right his wrongs at the court's discretion with that immunity deal. But you can't straddle the fence like that. Either you're going to work with the state and lock the members of YSL up, or you're not. And then you can be on the side with them and your lawyer fighting for yourself along with the rest. Okay? But, so yeah, but I will say he, in my opinion, I don't know if he did anything to Mr. Thomas or not, but based on the information that they was able to corroborate, it sounds like whatever he told them his whereabouts was, he was not there. He was not around that time when that occurred. Based on them not adding him to this, but then again, I don't know, because he got the immunity. I don't. You know what? I don't know. Y'all leave your thoughts in the comment section. Derived from such testimony or evidence shall be used against Copeland in any proceedings or prosecution for a crime or offense concerning which he or she testified or produced evidence under court order. However, Copeland may nevertheless be prosecuted or subjected to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify, or in producing or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of this state, the United States, or any other state. So this is right here his deal. He could go in there and wait. Let me make sure I'm saying this. May nevertheless be prosecuted or subjected to penalty or forfeiture for any perjury, false swearing, or contempt committed it in testifying or failing to testify, or in producing or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of this state. Okay, so Prissy, if you're still in the chat, what would you say to something like this? And I think I need you up here with me, if that's okay with you. You can call in on the call-in number. It would be better than you trying to type the answers in the chat. If you're still here, let me know so that way I can put the call-in number in there, so that way you can call in and give me your opinion. Let me just put that in there anyway. Okay, if that's okay with you, because it's going to be too much to type. So that's the call-in number. If you are still here, let me turn my ringer on so I don't miss the calls when they come through. But I would like to hear your thoughts on this piece right here. Like, what are they saying here? That, because if that's the case, then he should have testified. He should have testified. And in him testifying, what he did, failing to testify, or I feel like he did what he did. He definitely gave them what they needed, even though it wasn't what they wanted. He fulfilled the obligation to testify, even though, like I said, it wasn't the way they wanted the testimony, because that's why they pulled up his recorded audio at the minute marks that they was able to, insert. But I want to know, what's your thoughts on this piece up here? Okay. All right, let's get this in there. Okay. Hey, Queen, you're on the live with me. So if you can help me understand, what are they saying here with that one statement right here that I just read?
Scroll back up.
Let me get back to it. I think it's right here. Right up in here.
Okay, so
Okay, go ahead.
Okay, can you read it again?
Okay, it says, so however, Copeland may nevertheless be prosecuted or subjected to penalty or forfeiture for any perjury, false swearing, or contempt committed in testifying or failing to testify, or in producing or failing to produce evidence in accordance with the order, but shall not be required to produce evidence that can be used in any other court of this state, the United States, or any other states.
So that's kind of like a little bit of threat because we got you on the stand, so you need to tell us the truth or you're going to be prosecuted. Pretty much telling him to go ahead and tell everything.
Yeah. So, would you agree or disagree with me when I stated that once Mr. Copeland inserted himself by going down to the police station and giving them the multiple statements, that he had to been advised that he may need to be used in this criminal matter if it happened to go to court? They would need him to come and testify?
Yeah, because he volunteered to, to be a witness, pretty much.
Yeah.
Even though he tried to come in and clear his name, but he didn't do himself justice.
No, not after me reading this, he did not.
No, that was not a good decision. I don't know who advised him to go down and talk and volunteer. So it put him in a position to where he actually put himself in danger by doing so.
And I'm going to tell you, who told him to do that was himself, because the streets was talking the day that Mr. Thomas was unalived. We don't use the other word, unalived. And the street said he did it. So he I did not do this. So he went down there like, man, my family is in danger. I'm in danger because they really think I did this. And he really was adamant that he didn't do it. So he presented some information to them. He presented some phone records to them where they were able to locate his location and say, okay, well, he wasn't around the scene of the crime or anything near that. But these other people that he put in this, they was around that particular area, and the evidence that he presented to them, they was able to research it, investigate it, and corroborate it. Would you agree?
Yeah.
That's why we're here today.
That is why he is sitting up there today looking dumbfounded.
Wow.
Yeah, because he really thought that they were going to protect him on the street. Because he's more afraid of the streets than he is the police.
Absolutely.
And now he's up there making a clown out of himself in front of everybody. So the first thing was, let people talk. That means that they have to do their work to prove it that he was actually in there instead of volunteering the information.
Yeah.
No, that was not a good move.
That wasn't. He was scared for his life.
And I realized that he was scared for his life, then he should have moved.
He should have left. If he didn't do it, he should have got on. But he went down there, he volunteered all this information and got all these players locked up, 28 of them to be exact, they stated. Young Thug was one, and the rest, my God. My God.
And see, that's a bigger problem, because everybody, now he's even more in danger because all of these people got arrested. So that means that you would arrest. If you had hunker down, being quiet, let people talk, and then after a while, because they're not going to talk to the police, to be honest.
No. That's a fact.
So it would just remain as hearsay. And they can't use it in a court because it's all hearsay.
But see, he was fearful by obviously all the people that's got locked up, because all the people that got locked up potentially and allegedly would have been gunning for him. That's what he was fearful of. That's why he obviously named all these co-conspirators together and got them all locked up.
And then after that, well, he should have been nowhere to be found.
Yeah, but he didn't want to leave. He didn't want to leave his comfort zone. See, most rats don't want to leave. They want to stay there in the gutter, and then they get gutted because they decided to stay. Only the smart rats take the deal. If they're going to be a rat, they take the deal and then they leave. They don't stay. Those are smart ones, in my opinion. The dumb ones, they do this and stay, and then we hear something down the road. XYZ got knocked down. You know what I'm saying? Like, he put himself in this situation. There goes his support.
Yeah. Because I would have never said that. But then again, everybody's not like me.
Yeah, and he was scared for his life. So I don't relate, because at that time he was so fearful of his life. So my question is, all this time, from the time that he went down there and made all those 9 statements and got this case started, where was he at? Because nothing happened to him in all these years. What was he in jail?
I don't.
I gotta go back and listen. I gotta go back and listen to the lead attorneys. Find out, because the lead attorney, he got him to say a lot of stuff about his past tense that led up to this here. So I want to know, where was he at from 15 till now today? Where was he at? Was he on the streets, or was he locked up, free, safe in the custody, and now he's free from custody? When did he get out? And he may have been, because he was in messed up.
In witness protection.
Okay.
They probably had him.
And then he probably decided to let go of them and get out here and show himself up now that the trial has started, and then decided to come in here and free the kids.
And you know what? That could have been part of that deal where they were talking about that he has to present all the evidence and everything. So if you don't give us this, we can't protect you. Mm-hmm. So in between this time, it looks like, this is allegedly, that they were protecting him while they were getting all this evidence together.
Mm-hmm. That's what I'm getting from this. This is definitely what I'm taking out of this. Wow.
So he was on the take, in other words.
He was on the who?
I use the term like he was on the take. So he was working for...
He was on the job.
The law.
Mm-hmm. He was on the job. Mm-hmm. And then, too, what I'm thinking is, what could have happened is, yeah, he had to have, because they said he had another. I remember on the lead attorney's channel, he said something about Cross was on another case he was on prior to this case. See, people can't handle the truth, and that's okay. But obviously, that's what it is. So this is what makes sense to me. And oh my God! So yeah, he's trying to undo it.
Right here. Mm-hmm. According to the state of Georgia, hereby moves this honorable court to direct
material.
He's a material witness. So therefore, he was under protection this whole time.
He sure had to.
He was a material witness.
Mm-hmm. Because he is the witness. He is the material. He's the only person that was able to present this case, to get this case jump started. So because of, he was the key witness, he was the material witness. Without this testimony of him coming in, then, and he's trying to throw the case today, is not a good look for him. Because at the end of the day, regardless of him throwing the case or not, the people that's still locked up, they know that he went in there, and they hear the statements because they planned it out all over. He has to record a statement what he would when this first jumped off. Everything he said when he went into that courtroom was true to the best of his ability and to his knowledge at that time. Now he coming out here acting like he can't talk. He don't know how old he is. He don't know if he good or bad. I don't even want to get on this platform, okay? Because now, knowing what I know now, yeah, that's not cool. You know what I'm saying? And then he trying to come back and
he messed himself up again. I'm sorry, I didn't mean to talk.
No, he did.
I was also listening and reading, because when he was doing pleading the fifth, and it says here that since he was a material witness, he had to provide a testimony before the court. And he signed up for all of this, and they gave him immunity, but they couldn't take it back because he was. So they put him in jail. They remember
It's
because
with impeachment.
You pleaded the fifth. They're going to mess with your immunity for prosecution, so you better get on that stand.
Well, he did. Remember, he did get on the stand, and he did, you know, he still acted the fool, talking about you stank, you fired. You know what I'm saying? He did all of that stuff. But in doing so, he did it, you know, because he's embarrassed, for one, that he had to get up on that stand, and he didn't want to be there because, you know, he still want to be outside. He loved Georgia that much that he willing to leave his imprint in Georgia when it's all said and done. He will live and die in Georgia because he willing to die for that state. Instead of getting on and moving on and doing what you did, you might as well just forget Georgia, okay? And move. He should have just left.
He is not protected in Georgia.
No, he's not
protected in Georgia.
He's not. He's out there freely, and then he's traveling, and he's, oh my God. See, I didn't know what I'm reading right now. I did not know this because, like I said, I did not go in depth with this case. I just watched what I saw play out on TV and all the people that's, you know, covering it. Like, you know, the media outlets, of course, is who I follow. I don't follow the bloggers, but I do follow the media. But to have this paperwork in my hand, and I'm wondering if they was able to corroborate his whereabouts, maybe he was in the proximity. Maybe he had something to do with this, but they gave him a deal because he probably said he was not the shooter, allegedly. I'm just guessing right now. Just my thoughts.
And it's maybe, allegedly, there's other stuff on one of the 27s or some of the 27 that they can use in another case.
Yeah. On all the people that they got.
Information.
All the people that they got. And a lot of people went down because of him, you know, telling on them they had to take deals and all sorts of stuff. Because whatever, he knows everything about the state of Georgia. He know all the crimes that's happening. He know all the organizations. He know all the crime bosses. He know it all. You know, but he did inflict this upon himself. But for them to try to pinpoint it and make it appear as if the states is responsible for his safety, he did this to himself. But he, like I said, he's a dead man walking, and this is all alleged. And I'm sorry to you know, keep about it, but yeah, let me read this last part like you did. Accordingly, the state of Georgia hereby moves this honorable court to direct material witness. He's the direct material witness, Kenneth Cole, to testify in the trial of the above styled case until released by this. See, he's stuck into this case, and today want to release him. He's working for them until they release him. Honorable court from the subpoena, compelling said material witness to appear and testify before this honorable court. Further, should said witness refuse to testify after being granted, after he got granted immunity from prosecution, in order to testify pursuant to the code, the states move this honorable court to hold said material witness Kenneth Copeland in a contempt of court and commit said witness to the Fulton County Jail until such time as the witness purges himself to contempt by testifying as ordered. They had him by the balls. He was coming to testify regardless, so he can come on here and say he grown, like he don't know the answers to nothing. But when he in that interrogation room, voluntarily, the same way we saw the prosecutor yesterday and Alec Baldwin put herself up there on the stand, he did the same thing. He did the same thing to himself, and he voluntarily put himself in this case by becoming a material witness. And a material witness is the most valuable witness you're going to get because he has visual, firsthand information, firsthand knowledge, and firsthand evidence. He is a walking evidence to this case. He is the evidence to this case.
And they're waiting for him to purge himself.
He purged himself.
Keep acting a fool.
He purged himself. Remember, after the 7th to the 10th, he purged himself and he came back. So they released him, but not of his duties as in sworn in. So he's still stuck with this case until they want to release him. And when they release him, that's when the streets will get him. And I ain't saying it in a bad way, but that's when they will get him. because right now they still monitoring him. He's supervised. So him being outside like he's outside and being arrogant as he is and funny and all that good stuff, because he is very arrogant. The more he go live, the more I see him, the more my spirit is jumping out my body. Like, wait a minute, he's displaying his true identity. Because there's only so long you can hide and put paint on your body before that rain come down and wash it all off, and your true colors are going to show. And I'm starting to see that the more he go social media frenzy, because he's getting this internet fame. But see, what he don't understand is just because he becomes internet famous doesn't mean he is intouchable or untouchable, because shit, oh my goodness, he still, either way it go, he marks.
He does know that.
I hope he do.
And if you notice, he always looking around.
He stayed looking around. He was paranoid at the airport today. He was paranoid at the airport today. Wow.
Yeah.
He
can't keep his eyes straight and focus on nothing, because he always... Yeah, but you did this to yourself, dude.
He did. He really did. Wow. So what is this one? So let me see. The state of Georgia, having moved this court pursuant to compel the testimony of the witness. See, they are fighting for him, because the state is fighting for him because of the materials that he presented to even get this case to head to that as it is today. That's why they're so adamant. And I can't say if it's dirty or not at this point, because he put himself in this situation. So let me continue. To compel the testimony of witness Kenneth Copeland and District Attorney Fannie T. Willis, having determined that the testimony of Kenneth Copeland is necessary to the public's interest. Kenneth Copeland, having been properly subpoenaed to appear before this court to testify, and the state of Georgia having provided to this court sufficient reasons in support of its motion to compel the testimony of Kenneth Copeland, this court finds that Kenneth Copeland has been properly subpoenaed to appear before this court to testify in the trial of the instant case, and that the testimony of said Kenneth Copeland is necessary to the public's interest. I want to know how the young thug, I know, but I need to know a little bit more about him too. Accordingly, it is hereby ordered that the witness Kenneth Copeland shall appear before this court beginning Friday to June. See, he got this notice and he had a nervous breakdown. Because he was like, I went, I could just feel the energy. And this is just my opinion. This is not a fact. But just based on the way he's acting, he's like, he did not want to do this. He did not want to get out here and put himself more out here than he already did. But see, they needed him to do something so they can use that those investigations, those recorded investigation statements that he voluntarily walked himself in that courtroom, that precinct, and gave them those statements. Not once, not twice, not 3 times, not 4 times, not 5 times, not 6, 7, 8, but 9 times. 9 times.
This is an order compelling him. Like, you got to do it, dude. You got to do it.
Ain't no way out of this.
Back away.
Yeah, he can't get out of this.
Ain't no way out.
Ain't no way out. Only way out is he got to go in to come out. Ain't no other way. So he's trying to mess the case up. He's trying to throw the case, and he's trying to do everything that he can, and they're going to impeach him. So either way it go, he damned if he do, and he damned if he don't. Would you agree? Okay, just making sure. Okay, so evidence required. However, no testimony given by Kenneth Copeland as required under this order, or any information directly or indirectly derived from the testimony of Kenneth Copeland given by Kenneth Copeland as required under this order shall be used against said Kenneth Copeland in any proceedings or prosecution for a crime or offense concerning which he testifies under this order. Kenneth Copeland shall be subjected to prosecution. He has to do it, or to penalty or forfeiture, just like you said, for any perjury, false swearing, or contempt committed in testifying or failing to testify in accordance with this order. However, it is ordered that Kenneth Copeland shall not be required to produce evidence that can be used in any other court of this state, the United States, or any other states. Finally, it is ordered that should said Kenneth Copeland refuse to testify after this order is entered, said Kenneth Copeland shall be subject to being adjudged and contempt of this court, and shall be subjected to committed by this court to the Fulton County Jail until such time as said witness purges himself of contempt by testifying as ordered to do so by this court. And this order shall be entered of record in the minutes of this court, and any testimony given by Kenneth Copeland pursuant to this order shall be transcribed and filed for permanent record in the office. So now I kind of see why it may go against the defense and their motion may be denied, because he was compelled. And if he was under them and their immunity, then if they needed to have a conversation with him, he had Caleb with him right there. He had the court reporters right there, and he had the judge or the prosecutors there. So uh, honestly, after knowing what I know now, I don't think the courts did anything illegal in having that ex parte without the attorneys that was supposed to have been wanted to have been present. They felt they should have been present, but it's going to boil down to, was they supposed to be present, or should they have been present when it was something that did not pertain to them? It's something that this order, it was all about this right here, and this is the evidence that the prosecution has brought together. Because at first I was like Team Woody or Woody or whatever the hell his damn ignorant ass name is. Now that I know better, excuse my French, but I'm just saying. Wow, he put himself out here. So this is the ex parte hearing, and this is why when they read this ex parte hearing, he said this wasn't all of it. They said this was not all of it. He's trying to make it appear as if there's missing notes from this ex parte that says certain things that's not in here. That's the defense, what they're coming at now. So they're trying to do multiple things at one time. They're trying to, what they're trying to do here is, the defense is trying to get this case thrown out by any way they can. They're going past, they're like, okay, so what needs to happen is to make it fair. I feel, because of so much of, but see, I don't know if the judge ain't going nowhere. Glanville ain't going nowhere. I can't see it. And Krause, they not, because they're too valuable to this case, and
they're too much invested in this case too.
They definitely is. I just don't see them walking off of it either, because of they're invested, and because of they went through the lengths to protect him for possibly all these years. Because until I know where his whereabouts was from 15 till today, I can only assume he was protected up until now that the trial is out. Now he comes out, because I hadn't heard of, I heard, but I didn't see or hear him as we're hearing and seeing of him today.
He was somewhere hidden.
He had to been. He was girl to the flow. He was grounded with the ground. He was in the dirt. He was in the trenches. He was hiding. But let him tell it, he wasn't hiding. And he probably tuned in. He probably don't like this, and that's fine. I don't care. I ain't here to make no friends or meet none of these people. I'm not vested in this case. I'm just here to report what I'm seeing, so the viewers can have some clarity and some understanding as to what's going on with this case and why, things is happening the way it's happening. They don't want me to be on this case because they know I'm going to call it out. I'm going to see a spade. I'm going to call a spade. I'm going to see a foul, and I'm going to call a foul. So this is the ex parte hearing. I guess if you got the time, I do, because I'm curious to know more now. This definitely just sparked my interest.
I want to look at this, what you're looking at, but you said it's a whole bunch of pages.
This one is 81, and then I have another one that's 28. Did you want me to forward this to you right quick? Because I can. Okay. Did you need it in your possession? You want me to forward it to you right quick?
I want to see what's going on, yeah.
Okay, hold on. Let me forward it. I can do it while you're
I'm curious to know more now.
Oh, is that me? Okay, that was me all on my speaker. Okay, hold on. Let me see. Go to my emails. I thought I sent this one to you. I guess, right? It was so many that came, I couldn't count them all. Okay, here. Okay. Yeah, this is a lot, girl. He put himself on trial.
From the wording, it looked like he tried to back out.
He did.
Then they had to put this order.
Say it again.
He was held in contempt. He put this order out.
Mm-hmm.
And I'm going to say something about the attorneys that wish they were present, but I don't know if they can, because he might not have had them as representation when he started giving evidence. That's a difference there too.
Because he walked in, voluntarily gave information, and they recorded it. And then he didn't have representation at that time. He walked in there with no representation and gave up a lot of information that caused all these players to get arrested. Every last one of them. And most of them took deals, and he still got several of them on trial, but most of them took a deal and got out of there. And they didn't have a choice because their backs was against the wall. They was either they took a deal and just all they did was acknowledge that, yeah, YSL's a gang, so they can be free. That's all they wanted. The courts wanted them to say that was what it was, so they could walk away. And then if they have to come and testify later on, the people who did take a deal, they just have to come in there and say, yeah, this was a gang. It's coming in now too. You should get it in a second.
Okay.
Yeah, he put himself in there, honey, and then try to, like I kept saying, I was like, when I watched his testimony, the first thing I said, oh my God, he's throwing the case. I was rooting, like, okay, and I still ain't mad at him for throwing the case, but it's like you still caused this case to be in effect. They had nothing without him. I don't know why it's so slow sending, but I'm looking at it. It's coming in. Yeah, he he can't blame nobody but himself on this one.
He is a stretch. In the streets teach you nothing?
Obviously not. Okay. Let's see. It's taking so long to send. This is a large file. Hold on, let me take this off of my screen for a second. Let me send it from my computer because I'm trying to send it from my phone and it ain't working in my favor. Okay, here we go. Let me say this. State's response. Okay, boom. Let me go out of here. And let me send it to you. Where you are right here. To you. There you go, right there. Boom. Insert the file. Okay, which one is this one? 7, 9. This. Make sure it's the right one. Oh, shoot, no, that's not the one. Okay, it's the response. This boy, he did this to himself. So now he's trying to throw the trial. They know what he's trying to do. They not dumb. Just as much as we could break this stuff down and see what we see, they see it too. Why is it only giving you 10 pages? That's crazy. Hold on.
And I was like, the whole time I would see him testify or sit up there, and I was like, that boy's not dumb. He knows what he's doing.
He's very smart. He speaks it fluently. And sitting here trying to play it on the prosecution head, they ain't going for it. Them people. One thing I say, and I don't agree with everything that they do, but in this matter, they only trying the case because of him. Okay, it should come. Tell me when you get it. It says sent. Okay, it's sent. I had to do it from my computer because I don't know why. It was playing with me. Let me get out of that one. State's response. Okay. Here. Girl, today that breaking news with Trump. So much is happening in the world. Okay, here we go. Okay, let me share my screen back up here.
Okay, I got it.
Okay, cool. Okay. Let me get my screen share. Okay. Well, now let me go back down to where we were. I think I was on page 20 something.
Oh.
If it helps. I'm going to start at 20. Oh, I got to blow this up because I don't got my glasses yet, child. I can't see nothing. I'm blind as a bat. Girl, I'll let my daughter get hers several times before me because she needed it more than me, and I still can see, but it's time. I can't play with my vision. Okay, here we go.
Okay.
I think this. Yeah, we're on page 22. Well, I was reading at 2020. It was the one where we was reading his compelling. And then we got on to Exhibit C. See, the feds ain't playing. They not coming like this unless they got what they need. He was what they needed and what they need to try this case. He's making it complicated for them. But you know, and he's responsible for his own action. And now he's trying to turn a new leaf. Now he wants to be a law-abiding citizen. You know, he don't want anything to do with the gang and the game and the YSL and all this stuff. But, you know, somebody felt he was responsible for unaliving Mr. Thomas, a.k.a. Peanut, because I know that's just who it is. Has to be, because that's the only person that I was hearing this about. And so the streets are saying he did it. Because if somebody else did it, they going to know who did it. One thing the streets know is who took out somebody. They be talking. And if it wasn't him, and if it's who he said it is, and if it wasn't him, and he pointed out these people, he said, nah, it's them. Then he don't want them to come get him because they're trying to, because see what happens often is when, and this is the game, and because it ain't no rules in it, people will make it look like you did something that you didn't do because you have a reputation of doing something, and then they can have your life in danger because of your reputation and make it look like it was you just so you can get taken out for something that they did. And if you, because where I'm from, they say in the song, they say, you want to start some shit, take it to the other side of town. Draw the attention on the other side of town. Wait for the popo shift to change. Ghetto shooting range. Revenge on a rebound. More gang. And so, and that's E40, okay? Because I come from that era. And so that means you draw the attention on the other side of town, meaning on him and not them. And because he's known for stuff. And again, he may well not have done it. And if he didn't do it, he knew who did it. And he told on the people he felt was responsible for taking out, a.k.a. Mr. Thomas Nut. Okay? And that's just how the game go. So to save himself and his life and his family, he walked in that station the same day the dude passed away. He went there that same day. If you go back up to the top, they broke that down. He came in there.
What page are you on?
I'm on page 23 right now, but if we go back to the beginning of this here, you will see, and I'm going to find out where it was at because I read that. Where it said 9 times, he went in there. Let's see. Let's get into that because they breaking down why he's the witness here, the factual background of this particular witness, privilege to testifying. Let's see. Okay.
But he said he wasn't there.
He said he was
then
not.
That would be hearsay.
So he must have was there, and they protected him.
Here now.
Go ahead.
So this is my question: if he wasn't there, then everything else is alleged and hearsay. Mm-hmm. So that means that he had to be in the vicinity to say who did it.
Facts.
To have all this information.
He must be an eyewitness, a key witness. He's a key material witness. He's the witness to the materials of what happened.
For him to be a material witness.
He's an eyewitness to the crime.
He's got to be for them to take their word.
And let's
they would not take his word.
What is a material witness? Definition.
Maybe I'm looking at it wrong, but I would think that was
a material witness here it goes. A material witness is a person whose testimony is material to a criminal proceeding, and where it appears from an affidavit filed by a party that this person's presence for testimony cannot be secured by a subpoena. That's not giving me the proper meaning. What are two types of material witnesses? Can a material witness plead the fifth? How does a material witness differ from an expert witness? Let's see. See, an expert witness is somebody who has experts in criminology or something. A material witness is somebody who witnessed something. Let's see. He's a fact. He's a matter of a fact witness is called upon only to verify facts pertinent to the case. Expert witnesses, on other hands, may be asked to tell the court what their expertise leads them to believe in the case. He had the facts of this case. That's why they relied solely on him to present this fact to them. They was able to corroborate it. And they was able to create this RICO against all these individuals. He's a fact. He's a fact. He's a witness. He's a witness. And they want to know, can a material witness plead the fifth? Can any witness plead the fifth? In a criminal prosecution, witnesses can also plead the fifth. Witnesses called to testify can refuse to answer certain questions. They are allowed to do so only if answering would implicate them in a criminal activity. So only way he could plead the fifth is if an answering implicate them in criminal activity, if he's going to be implicated in this. So somehow he would have been implicated in this. That's why he was trying to plead the fifth. So that's why it's possible the streets may have gotten it right based on this statement. I mean, this meaning of a material witness. Because it states right here, if he's answering a question that's going to implicate him in this matter, he would have to plead the fifth. So he was trying to plead the fifth because he didn't want to implicate himself moving forward. But if he ain't did nothing and he said what he said, he should have been able to go back in there and repeat what he said in those recorded statements on that stand. He did not want to repeat what he said in the interrogation room on the stand under oath.
And see, that's why they gave him the immunity from prosecution. And he still tried to play them by doing the fifth. And then they had to put in the jury.
And it backfired on him, right?
Yes.
Yeah. Because you
got immunity. If you got immunity from prosecution, you might as well go ahead and say it. Because they can't do nothing to you.
Right. But what he's trying to do is he doesn't no longer want to cooperate. Basically, he's decided, I'm not going to get out there and put myself further out there. I said what I said in the investigation room. That's one statement. Until he get on that stand and say the same, that's when it matters, under oath. Because you can go in there and say anything in the statement, in the interrogation room. We all know that. But until you go get on that stand under oath and you repeat everything you said in there, that's when they'll be able to criminally use it against the people that they're trying to prosecute. So he decided now, I ain't fit to send y'all down. I'm going to go ahead and plead the fifth and let y'all niggas live one time. You know what I'm saying? And thinking that he is in the clearance. He's still a marked man the way they stated he is. He is. It doesn't matter. He put himself in that situation. But in this here readings, it breaks down what happened to Mr. Thomas. And I think I got into that. Let me see. Yeah. He witnessed something in that case.
Something that said about the materials. I mean, the weapons that were used.
He got the facts of that case. He got the facts of what happened to Mr. Thomas. He knew the facts of what happened to that man. And he went in there and he gave them the information that they needed to take the heat off of him, because he said it wasn't him. He didn't do it. That wasn't his work. He like, let them take the heat for what they did. You know, but then it's like, for him to try to come in there now and not go under oath, it's because if he go testify against them and the truth of the matter is he really is responsible. So on page 16 is where it breaks down the case of, you know, why he has to testify. This is on page 16, the whole breakdown.
16. Ex parte motion. Okay.
This breaks down the whole reason right here. If you want to read it, start at the at 1, or you can start at the top of the ex parte. It don't make no difference.
Okay. I was still stuck on the firearms evidence recovered.
Oh, where you was at? What page was you on?
Ex parte motion to compel testimony necessary.
Oh, you on page 16 with me?
Mm-hmm.
Oh, you said the
and then 17 is where the guns were.
Oh, okay.
The firearms. Sorry.
Okay. You want to read it out loud?
Yeah, let me take out speaker. Okay. Firearms evidence recovered from Thomas Jr.'s body and from the scene where Thomas Jr. was gunned down. I don't know if I can say that on YouTube. And there's a street.
Mm-hmm. Just say unalive.
Alive. Okay. Mm-hmm. Revealed that a 7.262 rifle and at least one handgun was used in the unaliving of Thomas Jr. and of Hendricks and Sanders, but they were just wounded.
Mm. So where are they at? Are they witnesses?
They didn't say that they were.
So this one, let me take this off the screen for a second, because I have the material witnesses. Oh, but I only have the list from the defense. I have Young Thug's witnesses list. So I'm gonna put this back up. I don't need to go off screen. Okay, go ahead.
Good. I don't remember seeing their names.
Mm-hmm. Me either. Not on that list. About it. Right. Mm-hmm.
So where are they?
Because they were because Hendricks and Sanders was injured in that moment with Thomas when he was unalived. Mm-hmm. So they have to be material witnesses too. See, material, they would be considered. So that would be on the prosecution side. They would have that list. I never saw their list. I gotta find out. I can get their list to see if there are witnesses on there.
Yeah, somebody was really thuggish in the sunroof. Mm-hmm.
Reckless. So, but he obviously knew a lot, and what he now I gotta go look at those surveillance tapes again to hear exactly what he was saying when he was in there with them. See, he said, like I said again, anybody could go in there and give a statement. That's fine. But a lot of people get arrested because people give statements, and then when it's time to come to court, that's where the case falls apart at, because they have to say the same thing in that statement on the stand, and he's refusing to repeat himself on the stand because obviously he has a change of heart. But either way it go, he damned if he do and he damned if he don't. So
I don't know what was happening between that time of 7:22 to early morning. When he went down, Sunday. When he appeared at the Atlanta Police Department.
He went down there at 722 Street, around 720. Okay, so what time? So 330 McDaniel, that's the street, revealed that a 7.62 rifle and at least one handgun were used. Okay, so then surveillance footage recovered from businesses in the area where the shooting occurred revealed that Thomas Jr., Hendricks, and Sanders were assailed by gunfire that originated from the sunroof and possibly window of a passing vehicle as the vehicle traveled west on McDaniel Street at around 7:22 at night on Sunday, January the 20th. In the early morning hours following Thomas Jr.'s unaliving, Kenneth Copeland appeared at the Atlanta. See, he came the same day. The same day.
That early in the morning, so he didn't sleep at all.
Child. So how is the streets talking? Well, I ain't gonna say they ain't talking that fast, because they talking at 7 at night. 7 at night till let me see.
Early morning.
Till early. I mean, he went early in the next. Okay, she doing the most. She doing the most. Hold on. She's doing too much calling. That's too much calling. Come on now. She obviously, you know I'm live if I don't answer your call. Don't do that. Okay, so in the days and weeks and months following Thomas's unalive, Copeland gave 6 additional recorded statements. Days and weeks and months.
9 hours long. So you want to stay there all day.
Right. He didn't want to leave the station. He did not want to leave.
So you were, by 8 o'clock that night, your nerves was that bad to early in the morning.
He couldn't sleep because, see, to me, that's a sign of guilt. Because now you did something, now you scared people for to come get you for what allegedly you did. Not saying he did it, just all alleged. He was fearful. So he ran on down there to that police station in fear of his life.
He tried to get it off his chest and thought that it was going to help. So that's why he pierced his little eye.
And that's usually what people do.
Yeah. So how did that happen so fast, though?
I mean, that was real fast. Who could have put him at jeopardy that fast? If it happened that night before and then early in the next morning, he already at the police station looking for refuge.
That means that the streets pointed you out.
They
so
definitely
you must have either been in the vehicle or vicinity, car following it, and you thought you were smart to leave your cell phone,
away from the area to show that you wasn't in the proximity, but yet you know all this firsthand information. Like they said, he knew information that happened at that scene, and for someone to not have nothing to do with it, you wouldn't know all that information like that. But if he did get that information from the streets, then he ran his tail down there and gave it to them. Said, man, protect me because the streets trying to get me. He's only still here because he was protected in this moment in time. For all this time now is what is given.
Yeah.
One of which was over 9 hours. Detailing Copeland. See, detailing Copeland's involvement. Oh, he already said he has some type of involvement. Look, he detailed right here on page 17, detailing his own involvement with the criminal street gang, YSL, and the YSL co-conspirators, and about the involvement of the YSL members in the unaliving of him. He's material witness. He was there.
And other criminal activity. That's why all these other people, they got something on them.
Yeah, on the other stuff that they have against everybody else. Copeland gave a detailed account of the events that led up to the unaliving of this person, Thomas Jr., as well as his own involvement in said events and of the events that and acts committed by Copeland and other. So he told on himself and he told on everybody else.
Everybody else.
Boom.
If you have detail,
Sorry, I had to blow the horn.
That's okay. I have a detailed account. So that means that's how you tell on yourself.
He told on himself and he told on everybody else. He didn't leave himself out.
He told on everybody else? That's what my grandmama said. If you can tell on everybody else and you got dates and times, what were you doing? How do you know? Because you were there.
You was there. So and again, he may have been the unaliver, but whatever he told on himself of being a knowledge to this case, he threw it off on somebody else, but yet at the same time say, yeah, but I was there. So obviously, yeah, that's why the streets was coming and gunning for him, and he ran out, and then he did what he did, and that's why we're here today. Wow. Now I understand the case better, because me and you both coming in on it on the tail end. I told you we was going to gain it together. You smart, I'm smart, girl. We put it together on our own understanding.
I was like, ain't no way that the law is going to take your information, and if it's hearsay, well, I heard that it happened here around this time. No. Detailed account.
Right. That part.
So
He's an eyewitness. Material. He's material because he's an eyewitness. He's definitely material. And he did this to himself. Now he don't want to go forward. I need to change my thumbnail. I need to change my title, which I'm going to do, so that people can come and see this breakdown and gain some better understanding. Because I sure got it tonight. And wow. So yeah, he can. So him being out here taunting the DA, getting his PO to authorize him to go to Miami for the weekend and have a little bit of fun and clear his mind of all of what he is facing and dealing with and stuff like that. You know, at the end of the day, unfortunately, and I don't wish this on nobody, what he did, he won't last long. And he thinking he's protected because he's social media he's doing this, he's doing that, he's over here, he's over there. Everybody that can get a interview out of him, get an interview out of him, because that's what's going to stand the end of time when it's all said and done, because he definitely is a marked man. And anybody around him, if somebody get bodacious to take that leap, you know, they going to, you know, the streets is crazy, but it's really depending on who really down to do whatever. And I don't wish no harm, and I ain't saying it in a way that's gonna mess my platform up, but people can read between them lines. And even now, looking back at it, as he was explaining himself on the lead attorney's channel, he basically implicated himself in so much when I look at it again. Because even then, I was being nice when I read that. When I was reading and breaking it down, I was being very generous, okay? Because I didn't know the facts as I know right now. I was being very generous, okay? I'm gonna acknowledge that and admit that. I was being generous to the reading, because and multiple times he was basically implicating himself. Even he was the person who brought the gun over there to that basketball field like that, and in that gym bag, and they picked him up, and he talking about, oh, they putting all these charges on me, they putting all these. Nah, you had that, they just didn't see that. And then you talking about the case, the camera was jumping and all XY. He and you can tell, even like I said, the paint is washing off of him. One thing he don't know is social media like that. He could be smart as he think he is, but you can't outsmart the social media people, because we watching on the outside looking in, and those that read between the lines and can decode the streets, like myself and others, is breaking it down to a science. And that's what I love to do, is break it down to an understanding for all my viewers to gather what's happening here. So again, he did a lot of stuff. He acknowledged he did a lot of stuff. You know, he's not saying he didn't do a lot of stuff, because he did do a lot of stuff. He's just trying to deny that he was responsible for unaliving this person. But at the same breath, he told on the people who he felt is responsible, because he's a material witness to it. He saw it. He was there.
He gave a lot of stuff. I'm just reading.
Girl,
just glancing over this.
Please. He did.
Yeah, because of some of these statements that he gave to the police and phone records. So he gave text messages and everything.
Did he? I want
to enjoy your time in Miami.
No, he back in Atlanta now. He flew back. He left. He back there today. I think they gave him.
That might be your last fun time.
But child, I'm looking what I'm seeing. I'm like, wow. So, you know, yeah, they're trying to make it now about the prosecution and everything, but it really is about him. And they're
trying to throw it off.
They're trying to throw it off. And I get it. I get they want to free the kid and everything. And I ain't saying that Young Thug is guilty for anything, but he's only in there because of Kenneth Copeland. Now, Kenneth is trying to right his wrong. But it's too late. because you can't go this far with these boys. You was trying to save your life, save yourself, and you was willing to put everybody in harm's way and put them in the custody of the authorities, knowing the belly of the beast ain't no place for people unless they should be there. And in this case, he felt they should be there because he like, wait a minute, I ain't trying to lose my life behind something I didn't do, even though I was down with them or whatever. But man, he's basically saying he ain't the trigger man. And so he's telling on the people who he says is. And he got them all locked up on top of this and all the other crimes that he, gave them information on. Them people didn't know half this stuff until he went in there and started talking and singing like a hummingbird.
See there?
What page you on?
They would have had. Oh, girl, I had moved on. But I was just like, see there?
Mm-hmm.
If you had never said anything,
you never would have been in this situation.
They would be looking for evidence.
Mm-hmm. They would have been. They wouldn't have had nothing. He gave them the bones, honey. He told them where the unalived bodies were at. And told them where everything was.
He gave them the meat and the bones.
He gave them the meat, the bones, the potatoes. He gave them the entree. He gave them the side chicks, and he gave them everything. He went in there like shit. And this is what happens in the streets, world, unfortunately. But like I said, I'm just here to read it, and what I see is what I see. He messed this case up, and he's messing it up, and they're not finna let him mess this case up. These people who they feel they know for a fact, due to the information that he gave to them, they know for a fact these people that is being charged is responsible for Mr. Thomas's unaliving. So that's why we're here.
And they're going to have to get somebody. Mm-hmm. They need to pin it on somebody.
Well, I think they need to pin the material facts on someone. And the material facts is coming from him because he's the one that was, and it's like, you can't play like that. What he did, he got everybody indicted. He shut the whole Atlanta down. A lot of people took deals, and then that's why, he's like, gonna this and gonna that. And somebody came in his live earlier while he was live on his TikTok platform. Somebody went over there and was like, they said something in his like he accepted them on his panel with them, and they said, you don't want me up here. He like, why? Get it off your chest. And then they just started talking about how much he is a rat. And you know who screen recorded it? Me.
Wow.
Yeah, I'll be dropping that too, so stay tuned, okay, because that's coming next. He talked too much.
Arrogant.
He's very arrogant because he feel like, because see, even when he be driving in the cars and he be recording and doing this thing or whatever, and he driving in cars, he be looking in his rearview mirror and he be like, yep, the police. When he went to what's his friend name that passed away, Threat, when he went to Threat's funeral, he said the police already got the address, so they already know where I'm fit to be at. So he letting the people know, like, y'all ain't gonna be able to do nothing to me because the police is watching me. They got my back. They still are watching him because he is a material witness. So yeah, they got their 24/8 surveillance on him. So he wish a nigga would right now. That's why he's arrogant. He's arrogant because he know can't nobody do nothing to him right now because the feds is on this case and the feds is watching him and the feds is right there. So if something do jump off, the feds gonna catch the individual so fast that they won't even get away with it. And I don't think nobody wants to risk their freedom to do anything to him because he's under feds watch. He ain't about to do nothing. He finna do just what he do. Go live, go to these 20 versus 1s, go to Miami, go back to Atlanta, cause court is Monday, and he gotta be in town and check in with the authorities and his POs and everybody else. So he's really and then like I said, he's starting to show his true colors. He even like when people call in and everything, like he's starting not to be funny is what it is. That's what I want to say. He really starting to lose his little internet sensation because he go live too much. And if he tune in or his people tune in, he go live too much. He does. And he's giving more of him every time he does it. And people read between the lines. Again, he don't know social media like social media is. Social media is not the same as the outside world. This is a whole nother world right here. This is different from being on the streets. Even though you can use a lot of your street knowledge on social media, as I do, but it's still different because it's avatars that's behind these platforms. If they're not showing their faces, like myself, there are avatars. I'm a real person. I really speak the truth as I see it. Other people get on here and they're gonna say this, that, and the third, and it's different. So he need to get some education on social media a little bit more before he start, going all on these different platforms and doing all the stuff that he doing with TikTok and Instagram and YouTube. And yeah, I get he want to get some of that money and everything, and maybe grow the channel and leave a legacy to his family. Make sure he puts somebody on there as his beneficiary, because yeah.
Well, just better log off.
Just log off. That's what I would do. Honestly, and nobody is telling him that because everybody is benefiting off of him being social media frenzy. They laughing at him, and he got his supporters that supporting him. And then he got the ones who is not supporting him, because there's a lot of people coming in that chat putting no rat faces up there. They was putting the little mouses up there, like a lot of them. I was like, oh my god, his channel is infested with mices because they all putting them in the chat. I was like, this dude is crazy. And he's what he's doing is, to me, taunting the streets too, though. He's and wherever he's at, he's somewhere, and he's not really hiding though. He's really not hiding. I can't say he's hiding because he's not. He got the feds on every corner watching him. His house is being monitored 24/20. Shit. Like
I'm wondering who's paying for these trips and stuff.
Girl, he be having the stacks on stacks on stacks. It's like, I don't know. He ain't pushing nothing outside. He ain't doing nothing like that. He getting money off the platforms now. And then I don't know, maybe they've given him something before or whatever to try, because they'll pay you too. He named his price, what you want, and they might have gave him some money. I don't know all the details that was in his contract. And anybody that's tuning in, y'all ain't hit that like button. Hit that like button. Subscribe to this channel. Y'all start subscribing to this channel. Turn that post bell notification on. Because, baby, we going to keep it real over here. We ain't about to sugarcoat this case for now. Not nobody. I just want to read it as it says. What you get is what is on this paperwork in front of you. This ain't me putting this paperwork together. So, just understand the truth is going to be set you free. And, yeah. So, look, Mrs. Bumpus.
And you haven't doctored it.
Not at all. They all got the same paperwork I got. So this is the ex parte stuff. It doesn't matter what we said. Mrs. Bub's like, right. Mrs. Love, it doesn't matter. And he didn't. And see, and I have not seen nothing from Mrs. Bumpus no more either. She been quiet now. Somebody was hating on her because she started a platform and started growing her channel real fast, and they ended up probably making her uncomfortable, and now she ain't even on social media like she was. Because in the first week after this was over, and she was fired and all this, that, and the third, next thing you know, she was running to her, she was bumping her gums. And then now, from what I'm hearing, the streets is talking, I ain't seen her. She intimidated because they said she was trying to come up off of him. It don't matter. Everybody else is. Why not? What was the difference with her? She was there. She was in that courtroom. She was in that secret ex parte meeting, and it looked like that was a bad move on his lawyer to take a vacation in the middle of his client having to testify. So they threw her in a situation. Honestly, I feel she was put in a situation. Mrs. Bumpus was the Kayla lady. Because she got
you better cancel or reschedule that vacation.
Thank you. How you gonna replace him for her? And that man didn't even that ain't that's a foul. I'm gonna call that a foul. Because that's what that was. Put her in a situation. Now this is messy. But again, look, it says, hey, Kayla, I wasn't able to see Kenneth today. He went on Saturday and tried to talk to him before his flight. But I have talked to his family. So at first, Kenneth was going to testify, but has now decided to take the fifth. Okay, see, child, how you was going to testify, but now decided to take the fifth. The fifth is not a part of his immunity. So he can take the fifth all he wants. The immunity that they gave him he's compelled to come in here and testify. There's no way he can get out of testifying. He did this to himself. He is a fool. And got all them people in this situation. They all is locked up. This is wrong.
Real wrong.
Because, my G. I'm trying to see what can I pull to what I'm trying to pull up. Child, I see what I see now. I know more. I feel like I'm caught up. Just reading this right here. I want to read all of this. Is the ex parte. This is the hearing from the ex parte, and that's why he's being funny, because he was like, "It's missing. Stuff is missing. This ain't the full ex parte." So,
well, what is missing?
He can't tell it because he's under oath. He can't talk. I'm fit to change my title because this ain't right, and I'm fit to put him on my thumbnail because this ain't right. I'm breaking down the Young Thug's recusal and response. I need to change this. What should I title this? Because this ain't it. This is more like YSL Kenneth. Wait, this is my YSL Kenneth Copeland is a rat.
Just put rat on there.
Put a rat? Cause he is. And but see, he don't wanna evolve into the big rat. See, right now he the little mouse. He the mouse. He the mouse that was in the house. But see, he gotta grow into this position to be the biggest rat because he don't want to get up there on that stand, but they got him by the balls. He, like I said, he damned if he do and he damned if he don't. So he might as well just get them people what they need. Go on and repeat what you said in the statements and quit playing with the prosecution. Because at the end of the day, he's going back to jail. And eventually they're going to stop playing with him and just put him back there. Right now, because he did. Oh, baby, and they dirty in there, so they know how to make a case happen that say it was self-inflicted. Okay, they not to be played with. I wouldn't dare play with these people. You do this, you got to stand on business. Let me see. I'm gonna say YSL Kenneth Copeland isn't standing on business. That's what it is. Isn't. Girl, he is not. He isn't standing. I got to put that. Isn't standing on business. Okay? Breakdown.
You got yourself in entanglement.
Breakdown.
That you want to go a few hours later to the police station.
Child, he went right after it. He went first thing in the morning. He was up all night looking out the window like Malcolm X. Free my people.
You had the coffee and donuts yet?
He probably brought the coffee and the donuts. He did. He brought the coffee, the donuts, and the hot dogs. And the noodles. Why he talking about he don't want no more noodles? Shit, you just put yourself on a one-way ticket to eat noodles for the rest of your life. You know you don't want to be in that cell. So you put yourself on a mission that's going to end not the way you wanted it to. It's going to be, it's two-way out for him. That's what I'm going to say. It's two ways out for him. And you know what that is. Down below or in that cell. That's the only way he's going to get out. He's not fit to be free the way he wants to be. So this moment he's having, he better live it up. I got to redo this thumbnail while I'm doing this. He got to live it up. He better enjoy it. He definitely, now I'm seeing it from a different angle. Because like I said, I didn't have this paperwork. This fell in my lap. Somebody wanted me to know more than I knew so I can gain understanding. And shout out to them. They know who they is. I'm not going to tell my sources either. Okay? But I have it. And I'm thankful. Appreciate them.
Thank you.
Right?
I'm reading it.
And I know now more. And I truly do believe, Yeah, I believe a lot. I believe now more because I know the streets. One thing I know about the streets is when they get to saying whatever they said it is, that's what it is. They ain't fit to just make up nothing because they want to get the said person, but then they rather do it than the police getting the people. So they was not fit to let him go to jail. They wanted him off the streets a different way. So what they did, what he knew this, and so he took it upon himself. And he went down there and gave them statements like he did.
And got that, he thought that immunity was going to save him.
The immunity wasn't going to do nothing.
Trial end,
It's over for him. I'm going to be honest.
It's not good.
It's over for him. It's definitely over for him. And I like I said, I don't wish nothing on nobody. I wish the best for him. I hope he, can make it out because he ain't out yet. Okay. And now that this is going the way it's gone, it's ugly for him. It's dirty work. What they say, this dirty work. Or rat work. Let me see. I'm changing my thumbnail.
Because after it ends, I hope you have somebody who can put you like on back of the truck or hide you somewhere and drive you like 5 states away.
He's trying to be outside. He's trying to be outside like he didn't do nothing wrong. Like he didn't do nothing wrong. He did everything to get this case where it's at. If he never volunteered himself in there because he was scared for himself, first of all, you a scared gangster.
A lot of them are. You think they tough, but they really scary.
They very scary.
That's why they be throwing out threats.
He was scared he was scared to death.
I mean, immediately he got scared because if you're gonna be there early morning hours, he was scared.
The street said, "Oh my goodness."
You might have been scared. You might have been scared before it happened.
The streets was talking, honey, and they was like, They was on his neck about this, and they is not letting up. We do this, dog.
There's no changing now.
Ain't no turning back. There's no way he can turn back because he put himself in this situation. He can't blame the prosecutors. He cannot blame nobody. He got to look in that mirror and be the man in the mirror. Literally, he got to be the man in the mirror. You did this to you, sir. And then you outside, and then you all arrogant. Then you all on social media showing your true colors. Like I said, he was extremely funny. He still got his little moments where he's funny, but the paint is washing off of him. His arrogance is starting to build on his arrogance. He's building off of his arrogance now, and he's getting more arrogant every time he go live. You see a different I don't want to say his damn name, Woody, because it's Woody now. Now your name is Woody. Nigga, you was in the woods trying to get away with this one, and now you have been exposed. I should have put exposed too. Like he really has been exposed.
And he's been only one exposing himself. They can't blame it on nobody else because you doing it.
And he did it. And then I did a lot on him, and I posted when he said he admitted it. Because like I said, every time he talked, he always putting himself out there. He was on the lead show. He had a lot to say. He shouldn't never went on that man channel, because even though he was trying not to talk about the case, he still was talking about the case indirectly. And they watching and they know it. And even going up there with Kayla, he was doing it indirectly. So again, he what did I say? Let me see what I typed it up. He's not standing on business.
Oh yeah, that's right.
He ain't standing on business. Wow. So it was something that they said in this paperwork. Let me see what the paperwork said again. It's on page. Get back up to the page. I think it was 17, 18. I think it was 17. Because where the gun stuff conversation was at 17. No, I want the part where he went in there and told these people this stuff. Look, right? Child, this is ugly. This is ugly for him. Where's my live stream?
And they got RICO charges. Oh no, I know they mad.
Yeah, because they facing the rest of their life because he put them as an organized crimers. Mm-hmm. I gotta put his thumbnail up here. This is about him now. This is no longer no reading of no. I mean, it's a breakdown, but the breakdown is the state put all the information out here, and they can say on purpose and all that. It's not. It's the facts. He is a walking fact. He is the walking. So, like I said, if something was to happen to him right now, I think it would set them free because the testimony wasn't strong. But then he would be gone. So
he would be gone. So he's no longer a witness. So
it's like they would be released. So it's like get him and then they can go, or he testifies and then they still keep them locked up and then he be released, but unless he gonna go into protected custody. But see, I don't know if that's another deal they willing to give him when he didn't take it. I don't know how they backtrack on those type of deals. I don't know that part.
Because they gave him immunity until he is purged from the end of this case.
No, he purged himself to testify.
So that's it.
Yeah. That's it. And purge, you know what the word purge means. Purging is what they say unaliving. He basically got to murk himself. Purging. He got to purge himself. He got to kill himself. Because basically that's what you do. You purge yourself. You got to take yourself out by getting on that stand. Because then you're done deal every which way you go. Like I said, he damn if he do, and he damn if he don't. Now I'm looking for I'm trying to put this thumbnail up there. I gotta go to here. I could change it over here. Child, he didn't he's done. He's toast. It's just literally a matter of time. He's toast. He's through. I'm gonna be honest. He through. I need to put this thumbnail right there. Choose this one and save it.
And if they were doing other criminal, say for instance, this is all allegedly, if the other criminal activities, if they were working with other organizations like a cartel, all of them are in jeopardy as well.
And they got them all. Because he said, and you heard they said, he told on, that's what I should have titled it. Kenneth told on himself and everybody else. That's what the title needs to be. I need to go back and change the title. He told on his...
I'm talking about, like YSL, they were working with a cartel. Like selling to them or whatever, doing deals. Yeah. So now the cartel is in trouble.
Yeah, because of where, remember, because he was in there talking about where they was getting the guns from. You can make a phone call right now, Young Thug, or pick up a gun, he go get the gun, he'll buy the gun, all that stuff. He told all that. They played that.
All them other people.
From the audio. Yeah. And he had first-hand knowledge, and they know he know this stuff. Oof.
Everybody that's connected.
Everybody. We can thank him. Yeah. This is not the way it's supposed to be. Oh my goodness. It sucks to be him. It very much sucks to be him. They ain't gonna want me talking. I'm gonna be reading this stuff because it's something I just want to read it now to continue to gain all the understanding. Because honestly, it's so much more to come. Because next week, the judge has to come back and say something because the trial is on hold. So they got to figure out what they're going to do to move forward. They're going to have to adjust the rules and start really calling out the prosecutors. The prosecutors, in my opinion, they don't need to do nothing shady when they got the material witness. They just got, he has to do what he has to do to keep this case moving. Whatever they got to do to rectify the situation, I don't know how that's going to play out. But I don't see this case they're not fit to let this case go. And it's too much to let go. And the higher ups is going to pull every string they got to keep this case in Glanville and convicted in Glanville. It's too much. They're not fit to, this case ain't going nowhere but right where it's at. And that's my honest opinion on the outside looking in. And I'll see if it comes to pass come next week. That's my prediction. What's your prediction?
I think no, it's too much time and invested in what they've done, like on the prosecution side for them. They're going to get it moving again. Mm-hmm. And I don't think the judge is going anywhere because it's probably, allegedly, other judges may not want to take this case.
And that's what it is been said, that they don't want to take this case. No one wants to touch this case.
It's too much entangled. You can't untangle it. So they got to move forward.
They have to stay on the case. So this case is not going anywhere. From my perspective, on the outside looking in, it's going to be where it's at in Glanville, Glanville. They're going to be on it. This is what it is. Fulton County or whatever they call it. I'm not from out there, but yeah, it's going to stay where it's at. That's how I see it. I can't see them moving it. And I see they trying everything that they can to move it. But, Peanut, oh, rest in peace, that man. Copeland, he did this. And anybody reading this gonna see, based in part upon the statements that Copeland gave to the police, 5 YSL members were indicted for unaliving of Donovan Thomas Jr. and 28 members of YSL were indicted for violation of the Racketeering Influenced and Corrupt Organization Act. So that's how they got their RICO, because of him. And then he, in return of them getting all of them, he took an immunity that don't get me for telling you everything that I know about what they did. And that's how he got his deal.
Me for what I did.
For what he did with them. So take me out of it. I'm going to give y'all what y'all need. Lock 28 up plus 5 additional. And just free me with an immunity. Let me run around these streets because they ain't going to know I did it. But now they know. But then now he's trying to backtrack on it. And again, there's nothing he can do to save them from facing 12 because of what he did and being that material witness. He is an eyewitness. He is not only is he an eyewitness, but he was a part of this organization. He was a part of YSL. He was a part of this RICO, but they just can't put it on him because it's like the first person that get the deal. The first person to get the deal is the person that they take care of. Everybody else don't get that same luxury. They just need one, and he's the one. He was the weak link. They only gave it to him. Only the weak links is the ones that take the deals. He really wasn't about this life. And we know he wasn't about this life because he spoke about how his mama was really good to him before she lost whatever happened to his mama. She's no longer here. Rest in peace to his mama. And so he decided to lean on the streets. And he ran into this crew. And he wanted to be down with the get down. And then he started being reckless out there. He wanted to make a name for himself out there. And he did. And in doing so, he saw a lot of stuff and he knew a lot of stuff. And that's usually how it happens. And then it'd be the right ones, the person right up under you that you think is your right-hand man, be the one to flip the script. But see, the people are trying to say now, well, nobody had his back. Matter of fact, he said he was locked up when I think about it from the lead attorney's platform. He was locked up until, I want to say, 21 or 22. But it seemed like he got out right when Thug went in. He was in there for something else, though, unrelated. And maybe that was a deal to get him out. And see, he talked about firing 2 lawyers who wanted him to talk to the prosecution. Remember, if you watched the lead attorney's interview he did with him, he said that in a case that wasn't related to this case, that he had to fire 2 federal lawyers that was court appointed to him because one lied and said he was willing to cooperate, which he said he claimed he wasn't, and then he said the other one came in there talking about just take this deal, or actually even went ahead as far as signing off on him willing to take a deal, and he said that was not true. But they let him. He said. Then he get on the stand. He said he was telling them people whatever he had to tell them to get up out of jail, and that's what he's trying to bank on now. That he was just saying anything. Yeah, but your anything was corroborated, and it was found factual, and you was found to be a creditable witness.
Because you didn't think that they were going to look into it. I don't know why you thought that. When you provided evidence.
And got the whole crew taken down, and others violated in a big old racketeering act. And they got them all. My goodness, he was
That's a whole neighborhood.
Which neighborhood?
I said that was the whole neighborhood.
Yeah, he took down the whole town. The Zone 3. Is that what they say you got to stay away from? Yeah. So that's why every time he go live, you guarantee to see somebody in that chat throwing up the rat signs. I mean, 1 million of them was up in there today. And one got through on the line. Somebody wanted to request to be on his live, and I managed to be there, and I heard it, and it was screen recorded, and I will be dropping that as soon as I get the time to drop it. I'll put it out there because that's crazy. I don't know if I'm going to cut just that clip out and play that, or I think I'm just going to have to play the whole lot. And when he go, he be going. And he loved that because he feeling like normal in those lives. And that's what social media wants to make you feel. It wants you to feel accepted into society. It's a social society. They wanted to know what the secret society looked like. Well, hell, here it is. Okay? Oh my goodness. He did this to himself. And I know they tuning in because they jumping in and out the chat. Just hit the like button if y'all don't stay long enough. Y'all heard what y'all wanted to hear. I figured this things out. So all the other, I don't know what they doing, but I'm looking in between the lines. But I see a lot of people jumping in and out. So just hit that like button, y'all. If you don't stay long, hit the like button and subscribe. Give me your subscription while y'all tuning in. All a few of y'all that's up in here that's been jumping in and out all night, trying to hear what I know, and now you know. Period, point blank. Okay. So
I mean, you there for public interest, so it's out there.
It's
you
there.
Want to read it for yourself?
It's there. It's public records. Okay, go to Piecez and uphold and put this case number in there, and you'll see it for yourself. Okay, this is public information. My. So yeah, he threw. Again, he damned if he do, and he damned if he don't. Let me see what is this.
Don't go back over there where you used to. Well,
he can't go back. He can't go back, but where he's at is not really a secret. Like I said, he's so arrogant. He letting people know, I'm outside. I'm not hiding. He's pulling up at 20v1 because he got the feds right behind him telling him. They sleep. They don't sleep. They up on 24-hour shifts watching this man because he's too valuable to their case. Nobody is about to try him knowing that this is a federal case. He can walk the streets all he wants to, play basketball, ride his four-wheeler. He can do all the stuff that you see him doing. Ain't nobody going to touch that boy right now. I can guarantee that. Nobody's going to touch him. So yeah, he can be as arrogant as he wants. As long as this trial going on, y'all going to get to see a whole bunch of Wody. Y'all going to see a whole bunch of him. He ain't going nowhere no time soon until this trial is over with, and then they release him back to the streets. And somebody came in my chat and they actually said that too. It's in my comment section in some of the videos. They be coming in there and somebody gave me a whole rundown of him and said a whole bunch. So, yeah. Like I said, he's definitely got some funny moments and everything, but now he's starting to get a little bit arrogant. He's talking too much. He's showing his true colors and his paint washing off, and he's still straddling with that life that he once lived. And once he did this, he no longer wants to live that life anymore. He just wants to be normal. He wants to be a part of a law-abiding citizen society. He don't want to be a part of any organizations or criminals or anything like that, because he feels like nobody wasn't there for him when he was locked up. Nobody didn't put no money on his books or anything like that, and he feel he was left alone. So in doing so, even though he did this prior to him going down, and then nobody wasn't there for him, he said people would see his family members, wouldn't give him nothing, like put this on his books, nothing. Nobody didn't show any care, concern, or interest for him. So, you know, it probably grew his arrogance more to say, you know what, I'm fit to stand on business. But now he decided he don't want to stand on business because the world is watching, everybody's tuned in, and he just not feeling it. And he don't have that right to change his mind on something that he got this all kicked up. And the feds ain't fit to let it go. He played with the wrong people. So you could say he outbeated them all they want, because even I thought that he outbeated the feds until I start reading this here. And then I want to read the ex parte. I think tomorrow we can come back and read the ex parte and get more insight of what was said in that meeting. And then let me decide if there's anything missing according to my own understanding, or is this everything that was in the ex parte? Now, they may have been redacted something. I don't know. If they put that in there, then they should say redacted this X, Y, and Z. Or it should be a page with a black lines all the way through it where we're not able to read it. But from this looks of this, and it's like a lot of pages. Look, let's see, probably, is he?
I see like 81 pages.
It says 81, but remember some of them is from the response that they gave.
Oh, yeah.
And then the exhibits that they exhibited here, A, B, and C so far. So Mr. Copeland, y'all don't want to show the people how y'all did me. This is him in the ex parte room. The court like, look. And then Mrs. Hill said, if we can't find clothes, then you may have to until tomorrow. Mr. Copeland, I prefer to go in like this. Mrs. Hilton says, I understand what your preference is. Mr. Copeland, nah, don't hide it. Mrs. Bumpus, can you make him put on clothes? Mrs. Hilton, no. Mr. Copeland, I want to go in there like this. Mrs. Hilton, fine with me. The court, oh yeah, we got to break this down tomorrow. This right here is going to tell what was happening for what they were able to share with us in the so-called secret meeting that the attorneys that are complaining like Steele wasn't privy to. So again, and again, and I get what they're trying to do. I get Mr. Steele's point. Everything that they can use against this case to help his client get out of this situation, they're going for it. But see, what they're not going to do on the court's discretion and under the court's watch is use Mr. Copeland to what he's doing to get out of this. And when I said I was being generous when I broke down his interview with the lead attorney, I was, because there was times where he even emphasized in that interview with the lead attorney how smart he is and how he paid attention when he was in school. And the only reason why he was in special ed is because he had some hearing issue. Okay, so ain't nothing wrong with him. And then you hear the way he talked fluently in the damn the interrogation rooms, not once, not twice, but 9 different times, in days, weeks, and months to come. Like goodness, he was running and running. So yeah, we gotta go.
I guess he was working for him then. When he had to keep coming back,
he definitely was. He was running for them for 9-some months and giving them people information for an extremely long time. Yes, he was. Until, I guess, like I said, he got his, because if I go back and listen to the lead's interview, which I most likely will, just to refresh some of my memory and thoughts, he said he did the most when he went over there. See, he don't know that was a setup. He did not know talking on this while you have an open case. And even the other lawyers that I've been watching speak about this case, even they felt like, you know, he shouldn't be doing this and he should not be doing that. And what he was doing up there with his with the fired lawyer Kayla, he should not have been doing either. He was out here arrogant, thinking that he's getting away with something and thinking that he's helping the situation. He really put himself out there that much even more. It's not a good look. However you flip it, the bread is going to be the same on both sides. It's not a good look for him.
He fired.
He fired. He fired himself from the. He fired himself from the streets.
I thought she said I quit before he fired me.
Right. Right. And then she got on her platform. She started talking too much. And make sure y'all hit the like button, everybody that's tuned in still. She got on her platform and was like, he helped me out by firing me because they wouldn't release me and they was trying to keep her there, to proceed with him as legal representation because his other lawyer was out of town. And she needed to go because whatever she claimed she had to do. And see, that's where the discrepancy came in, and where the YouTube streets and all the social streets started talking about her clout chasing off of him because she started the platform and her number went up. I don't know where she was at. The last I checked, she was at 12,000. She may be at 50 today. I don't know. But she grew in days. I'll tell you that. He grew. His social media, he's up there. That's why people reaching out to him and all that stuff. But again, that don't protect him. That's just putting you more out there and people to know where you are. And for him to say he don't trust people, whoever he is trusting, he better hope that they don't get paid and flip and set him up and put him somewhere he don't need to be. Because you really, in this situation he in, baby, I wouldn't trust myself. Okay, it wouldn't be nobody around me. This is where he would have to go into total isolation. He might as well just go to an island somewhere and just live it out. Because being in America ain't for him. It's time to move. And somebody seen him at the airport. I can't wait to drop it because, man, he was being sarcastic because he was trying to show this big guy that was a heavy set dude. He was oversized. I mean, he was humongous. And you can see, you'll see it because I'm going to drop the video. Like I said, if he don't know, everybody is watching. He is hot. Okay, he hotter than Krishan Rock right now. Shit, and she was hot. Okay, so I think this was great. I'm glad you was able to come up here, my co-host. Y'all give it up for my co-host in the building. Okay, because honey, you brought that A game. You brought your knowledge. I appreciate you. But I think we did good. We went over 3 hours and we broke a lot of this stuff down. So I'm gonna see what time I got available after I go to church with the kids and the family and stuff. And then if I can come on and we could break down the ex parte, I would love to read that ex parte, and just see what's all was said in there because he was fluent in there. He wasn't sounding like he was sounding on that stand in the ex parte from what I just was reading. And see, and one thing about me, I don't review nothing until I'm live. And the reason why I don't review anything while I'm live until I'm live is because I want to give my natural reaction to my viewers. So they're getting my natural reaction. I never looked at none of these documents that I've had that I've sent out. I've not seen any of this stuff until today. This is the very first time I opened up the file to actually look at it. So when I read it, it has to be authentic. I can't pre-read it because then my reaction is already through the first reading. And I may can give you another one, but it won't be the same as that first reaction. And that first one is captivating. And that's just
this
FYI.
Is all captivating.
That's just FYI.
I'm just shaking my head at this stuff because I'm just like,
yeah,
no guidance.
None. And he went in there on his own. Nobody told him to go down there. He went on there on his own because he was fearful that the streets was saying he did something that he claimed he did not do. Okay, so then why not leave it at that? Just say you fearful that people are saying that you did this and you did that. In order to get the protection, he had to give them everything that he laid out on that table. He couldn't have been able to stay free this long or, in the land of the living. I'm going to say it like that. If he did not give them all of this, he would not be here in the land of the living today. Unfortunately. And like I said, I don't wish nothing on nobody. I wish the best for everybody. I want to see everybody winning and shining and getting ahead. But baby, when you gotta do this, you know, there's I mean, and this don't make me, you know, look at him the way that the streets will look at him. I have to say it like this because I see it from both sides, the school smart and the street smart. The school smart, you would be like applauding someone like him for taking the stand, acknowledging I did wrong and these people did too, and this I was a part of this and this is what I did. People, the what is it, the Caucasian culture, they applauding this all day. The African American community is not applauding this because there's rules in that type of low income, low housing, low income community, the hood, the urban community, however you pronounce it or say it or whatever. They don't applaud this. They look at him as rat because they are not knowledgeable. They think the streets is their friends. They think that they own these streets. They don't even own the house they live in. They're either Section 8ing it or renting it, okay, or subletting it, or putting it in somebody else's name. Is always a hustle to get up and get ahead. Everybody, please hit the like button that you're still tuning in. If you have yet to hit the like button, please hit the like button. Subscribe to this channel. Thank you in advance. And so yeah, tomorrow I would love to break down the ex parte and get some clear understanding more. As clear as it is for me, I know why now we're here, but I want to see what's happening after everything has transpired in this ex parte to get some better understanding, to know what's going to happen come next week. Now we'll be all caught up.
Yeah, I don't have to watch videos. It's all right here. I'm gonna read it right here.
We ain't gotta watch other platforms. We building together. And again, you start one. I'm supportive to you. Whatever you want to do, I got you. And I appreciate you for being a co-host here on the platform, with your knowledge and your insight. And we put these pieces to the puzzle together, one piece at a time. We're gonna just call it as we see it, as we're reading it. So that's going to end my live. Let me end my live with these folks. So anyway, let me just say my outro. I'm going to let my co-host say hers, and I'm going to go. How do you want to conclude with your outro tonight to the viewers? Short and sweet. Short and sweet. That's it. All right, y'all. Y'all heard it here first. That is my time. If you guys are new to this channel, welcome. If you return it, welcome back. If you have not subscribed to this growing channel, go ahead and hit that subscribe button. Turn that post bell notification on to select all, because you definitely don't want to miss me, yo girl, Hollywood Next in the building. Bring you guys yet another one with my co-host. And I will see you on the next one. Peace.